Good morning and welcome to the UK Adjudicators Adjudication Arbitration Conference London 2022. I want to start, as I hope you would expect me to, by paying tribute to Sean Gibbs for the excellent concept that he has developed and for the characteristic energy and enthusiasm which he has adopted in implementing it. It is a first-class performance on paper. We're going to see how it turns out. But now you've done your bit. You've got them all here, you've got the audience here, and you've got the panels here, well, most of them anyway, can't have everything. You've got the venue works, the food was lovely, the people are largely here, old friendships renewed, new friendships made. So if I may say so, Sean, a shout out to you for a job, at least so far, well done. What's that great line? He who can does. He who can't teaches. He who can't teach teaches teachers. I think that's the approach that Sean's adopted with me. He who can does. He who can't chair. He who can't chairs. He who can't chair chairs the chairs. Now, it's my great privilege to introduce today. I'll be around, I hope, during the day, though I give a disclosure in advance. I had my COVID booster yesterday, so if you see me sort of snoozing in a corner or not here, don't be at all surprised. But it's my job to introduce today, and I'm going to do, if I may say so, two things. One is I'm going to give, I hope, some context to the importance of this event and its nature. And secondly, I'm then going to tell you just a little bit, very, very briefly, about what's going to be happening during the day. Context. We now know that adjudication is now very much part of our fabric. I was at a 39 Essex Singapore party at the weekend, and we were talking to our colleagues in Singapore about adjudication and the effect on domestic construction arbitration and how adjudication had worked and whether it was accepted. And as we explained to them how it was now, whilst it was statutory, it was the dispute resolution method of choice, and that it very nearly always produced an outcome, and it wasn't simply the starter of the menu for the long proceedings to come, and the sort of slightly wide-eyed approach of, is that really right? And we explained it. And it made me reflect, and I know that we had the 25th anniversary of the Act and therefore the opportunity for sort of formal reflection, but adjudication has been a remarkable success. And one of the reasons for that, I think we could all trace a whole package. Obviously, one of the reasons for that, the context is that the judges have been very supportive of adjudication and have enforced it. But secondly, the other, and that's been a great help. But secondly, the key, and I think Lord Justice Coulson's made this point in several judgments, is the quality of the adjudication community in terms of its technical knowledge of the way in which adjudication works, its wisdom in the decisions that it makes. And that without that community coming together, it seems to me, and I'm sure many of you, I'm sure, would agree, that it's that quality that means that the industry can have the confidence that it does in the process and the people. Now, how has that confidence arisen? Because let's be candid about it. When I said this once at a conference, I got a solicitor's letter from an arbitrator. The construction arbitrators community, before adjudication, did not enjoy the confidence. You know, John's laughing. Perhaps he acted for the solicitor why I got myself into such trouble, and those of you who know me will find this difficult to believe, was I actually was foolish enough to mention the appointing body that was responsible for the worst appointments. I shan't make any reference to the RICS because that would be quite wrong. In those days, construction adjudication was a real problem, and it was not. And the quality of the dispute resolvers, I remember when I was interviewed for my pupillage by John Blackburn, QC, KC, QC as was, KC as is now, and I'd been in a shipping pupillage to start with, and he said the one thing you're going to find is the arbitrators in shipping are marvellous, and the arbitrators in construction are rubbish. Now, so what's so fascinating is that with that background, over the years, this high-quality, highly regarded cadre cohort of adjudicators has developed. And the answer, and you'll see where this is going, why? The answer is events like this. And it seems to me that the way in which the industry, the adjudication industry, has reacted to adjudication by standard-raising events, accreditation, training, articles, societies, newsletters, on and on and on. That has been what has been the key to it. But it's more than that. And here I am, a slightly sensitive ground, I know, from time to time, but it's also the peer pressure for quality and good behaviour. Now, we know that doesn't always work, and when it doesn't work from time to time, we know that the industry comes together to try and move it on to the next step. And I think that has been traditionally very successful. But these sort of community events are, in my judgment, a critical part of that evolution. And that is why you end up with training that is why it's so important to have the quality of training. Now, it's also important, and this segues into today's event, to have a, segues into this event, to have a diverse, and I mean diverse in subject terms, methods of training. You don't simply train how the referral works, natural justice, and that you do actually push yourselves, and are pushed by Sean, into new and innovative training so that that knowledge bank spreads. Now, today you've got 6 panels, and the first panel, who are sitting in front of you, will be dealing with sole or multiple decision makers, what's best. That'll be an interesting talk, I'm sure, an interesting seminar. My good friend Jeremy Nicholson and I spent 10 years fighting a case together. Difficult to believe that you'd fight a case for may have been longer than 10 years. But certainly it was a very long time, where Panatown and McAlpine, for probably half the rest of you, were in it. But that's the sort of case that now wouldn't survive adjudication. It might have been got over in 5 years rather than 10. So this panel will talk about sole or multiple decision makers. Then there'll be why adjudicate, and the mode's going to be a panel of 4 chaired by a distinguished chairman. Then consideration of why one should go to adjudication first as part of dispute resolution. Then a session about dispute boards and why they work. Then lunch. Very clever of Sean to try and take time-telling measures to avoid the dead slot so that everyone's asleep, so that they'll still be awake for the immediately after lunch slot. There's nothing worse than speaking in the after lunch slot. But today it should be all right because it'll be very early. Governing laws, issues in tribunals, so taking it one further step forward. Then the 5th panel, which I hope I'll be still here for, bearing in mind my COVID, experts, COVID jab, experts and lawyers' views on international arbitration, which I think will be a particularly interesting session. And then finally, and this makes the point and enables me to finish off on the point I started on, needed improvements in adjudication and arbitration. And that, for me, reflects the process that this conference is such an important part of. It is inward looking to train us, outward looking, though, to see how we can improve that which we provide by way of service for the industry. So welcome to all of you. Welcome to the panel. I hope everyone has a very good day. Thank you very much indeed.
Well, thank you, Paul, and I'm delighted to see that so far, at least, the COVID booster vaccination seems to have boosted your energy levels rather than slowed you down. So, to this session. 1, loneliness. 2's company. 3's a crowd. So which one of those numbers works best when it comes to people deciding construction disputes? And especially if you get the chance to specify that in the contract documents. or even, very rarely, to agree it after a dispute has surfaced. Well, 2 has never been popular because 2 people, one appointed by each party, might just disagree. What a surprise. In shipping and commodity arbitration clauses, it used to be specified sometimes with provision for an umpire to decide between the 2 party-appointed arbitrators if there was disagreement. But I understand that no longer happens and hasn't happened for quite some time. And in construction contracts, it has never featured, so far as I'm aware. So we can swiftly pass on from 2 as a serious option. One person deciding is the most frequent approach in the UK, as you all know, and also in common law jurisdictions overseas. And that applies to both litigation and adjudication and arbitration, although there's not much of that going on in UK construction at the moment. So why one person? Well, the main reason, I think, is that in the UK we have a touching faith that one person is going to reach the right decision and is not going to go barking down the wrong rabbit hole, something we've never seen with adjudicators or judges or arbitrators, of course. And we also allow very little scope for setting aside decisions, especially in litigation and arbitration. And in relation to adjudication, of course, the decision is generally binding, at least on a temporary basis, and in practice is rarely the subject of an application or action to correct. And of course, one-person decision-making does have powerful advantages in terms of, first, speed, and secondly, costs. For example, in relation to speed, if you had the sort of timescales for adjudication that are typical in Australia, it would be almost impossible to have the decision maker other than one person. Now, in contrast, 3 persons is the typical approach overseas in civil law jurisdictions and in international construction projects. And that may well stem from skepticism that one person on his or her own is going to reach the right decision. So in the German courts, for example, any civil dispute over 5,000 euros in value is likely to end up in front of 3 judges, something that just doesn't happen in the UK outside at least certain tribunals, but never at first instance in the civil court system. In construction arbitrations, the norm is 3 arbitrators, not invariable, but usually. And in construction projects with provision for dispute boards, typically large infrastructure projects under FIDIC conditions, the norm is 3 DB members. And there are a number of advantages. First, 3 heads are better than 1. It's often a good idea to talk with other people before you make a decision, as our latest ex-Prime Minister found out. Secondly, it does share the workload of writing awards or decisions, which can be quite heavy, particularly if one has a DB which ends up with effectively a final account sort of a dispute. Same applies in arbitration. Thirdly, it does give the opportunity to select people best suited to the dispute. So, for example, on DBs, there's the opportunity for complementary expertise. And typically, at the start of a project, the parties might aim for a dream team of an engineer, a QS, and a lawyer. And for a standing board, when one doesn't know what type of disputes are going to come down the pipeline, that's really quite a useful approach. So, in summary, those are the issues we're going to dive into in rather more detail in this session. Let me tell you something about our panel. And doing the diving into the issues will be 3 and hopefully in a moment 4 great panelists, each specialising in construction and engineering and able to speak from a huge amount of practical experience of dispute resolution over many years. So in order of appearance, we have John Miller, partner at Fenwick, Elliott. He started at the sharp end of the industry in M&E engineering work before becoming a solicitor. His practice includes both dispute resolution and transactional work, and he's now had more than 100 appointments as an adjudicator, and he also acts as mediator and arbitrator. And he will be followed by Richard Bailey, also a solicitor with a practice divided between dispute resolution and transactional. He is a partner and head of construction and engineering at Druces, well known to many of us in this room from his years of sterling work for Society of Construction Law UK as treasurer and then chairman. Then Seamus O'Doherty, chartered quantity surveyor and chartered builder. He has experience from both the contracting side and the professional side of very many projects worldwide. He's now director in Berkeley Research Group's construction practice, giving expert advice and evidence on quantum. He also sits as an adjudicator and an arbitrator. And finally, the temporarily absent Damien James, but eagerly awaited, also a quantum expert with a particular expertise in delay analysis and disruption valuation and disentangling global claims. He also sits as an adjudicator and arbitrator. As described by one grateful client, claims consultant, great guy, expensive, but will do the work in half the time. What's not to like? And I imagine he's polishing something off at this very moment on his way here. So let me also tell you a little more about where we're going on this. What our panelists will be focusing on is this. So John is going to start by focusing on one-person determination, and in particular from the UK viewpoint. Then Richard will also focus on one-person determination, but from the UK and also broadening that to an international perspective. Seamus is going to move us on to three-person determination from the international viewpoint. And last, Damien is going to talk about three-person determination, again from the international viewpoint and with particular focus on dispute boards and indeed practical experience in Africa. So that's what we have in store for you. Over to John.
Thank you for the introduction. I assume if I tap that. Oh, slides? No slides, thank you. Okay. John Miller, Fenwick, Elliott. You've heard that I act as adjudicator, but I also sit and act as advocates in front of adjudicators as well. So I'm just going to take you through in 8 minutes the pros and cons of using one dispute resolver to resolve disputes, and I'm sure most of you have got your own ideas. The first point that sprung to mind for me is it's cheaper. A single dispute resolver should be far cheaper than having a panel of 3. And the very last thing I'll deal with, does it really matter? because the point being is, in the UK, we've decided it's one dispute resolver who's going to deal with it at the first instance. It's normally adjudication, and it's far cheaper than a panel of 3. The parties need to contract into whether they want a panel of 3 to resolve their disputes. It should be quicker as a result. One diary, one person resolving a dispute. Often I find with panels, and I don't do a lot of panel work, just coordinating the 3 people's diaries can take a lot of time and effort via their clerks or otherwise. And just to remind you, Corinne Davenport, and I'm a bit sceptical of this, a statement was made there whereby the industry decided that rather than getting the right answer, the main impetus behind particularly adjudication was speed. Okay? So getting the right answer was subrogated to the need to get a quick answer. I, again, am sceptical of people who don't work in the construction industry, including me, saying what the construction industry wants. But speed is seen as one of the big advantages to having one dispute resolver. The other advantage that you often hear is you have some control, not with judges, but with an arbitrator, with an adjudicator. One, you have control over the appointment, who you're going to appoint. And 2, the process. I think that's the theory, but I'm not too sure it's the practice. Every adjudication, every arbitration I have, I always suggest, how about X or Y? And straw poll, about 50% of the time we agree it. And I normally agree to what the other side say if they suggest somebody who seems sensible. But often if you suggest somebody, it seems that there's a hidden agenda there why you want that particular person. And one thing I've got to say is I think times have changed a little bit since the bias cases of a few years ago. Adjudicators are much more alive to bias and are much more willing to declare if they've got an issue with a party or a firm of lawyers or such. I'm currently adjudicator on a matter where one of my ex-colleagues represents one of the parties, immediately declared it, and they just moved on. It's not an issue. So I find in adjudication as well that very often, once it starts, the parties couldn't even agree whether today was Thursday or not. So it's an idea to agree an adjudicator and agree a process, but the practice may be very different. Also, much is said of the tripartite panels about expertise. You can have a legal chairman, a QS as a wingman or wingwoman, or an engineer. Now, adjudicators, I find again, you have experts. It's very rare to do an adjudication with any sort of technical or financial issue without an expert, often both experts, on both sides. So experts often provide expertise to adjudicators and judges alike. Just one point, if an expert's duty is to the tribunal, to the adjudicator or to the judge above everything else, I'll go back to pre-CPR, why do you need 2 experts? Okay. Prior to the CPR being formalised, there was a big impetus to have one expert appointed by the court. If they both have a duty to the tribunal, not to the person paying them, why should you have an expert on both sides? But that's a debate for another day. Disadvantages. These are my views, not the views of my firm. Very often, and I'm putting my head in the lion's mouth here, the way adjudicators are appointed is a bit cryptic. It has changed quite a bit. We had one of the leading AMBs come to my firm who we felt that the adjudicators being appointed on large disputes, surprisingly, were the people who often gave lectures on behalf of that AMB and explained that they were changing. A more diverse panel, a different panel, and what have you. We still believe that on certain AMBs, if we have a certain type of dispute or a certain value, we can normally come up with 3 or 4 people who are going to be nominated. Okay? And many years ago, there was an organisation called the Umbrella Group. I think it's dissolved long while ago. It was when AMBs got together and held a conference like this. And the point made over and over again is, how are adjudicators appointed? How do you appoint them? And then there were various AMBs that were saying, we're going to be more transparent, subject to the Data Protection Act. I've not seen any transparency going further than that initial conference. There are certain groups that operate a CAB principle, text is very clear, but very often it's difficult to work out exactly how an adjudicator has been appointed or nominated. Another disadvantage with one-man panels and adjudications that we all realise here is hijacking. 28 days is a very fast process, okay? And the complaints are it gives rough justice. I don't think that's a complaint of having just one person, it's a complaint of the speed. Okay? And a point I made earlier, has the industry foregone getting the right answer absolutely right in return for speed of dispute resolution? Again, another criticism levied at the one-man panel is, well, lack of expertise. A big infrastructure project, you can have engineers, QSs, and lawyers sitting together. Okay? That's levied at adjudicators, not normally levied at judges, that particular criticism. But that is an inbuilt advantage in my view. If you can select a panel of 3, you can pick the people or the disciplines that you need to deal with your disputes. The biggest disadvantage that I see in a one-man panel, and again, particularly adjudications, is large disputes. Are they really suited to large disputes? Again, at the beginning of adjudication, when it first came around, there were comments made that, well, hold on, you can't put a really big final account in front of an adjudicator and expect it to be done in 28 days. Okay. Is adjudication really suited for large disputes? I have an adjudication at the moment, it's a final account. We are 3 months in. We had a conference call with the adjudicator yesterday afternoon. He's saying he hasn't read all the papers. He may finish it by next week or the week after, and then he'll give an idea of the timetable, and we've had to accept that. Just a 3-man panel can split the workload. Okay. So there is expertise and issues that crop up there. And finally, my last real point is, does it really matter? Because in the UK, we have statutory one-person adjudication. Okay. If you want to opt out, we can't opt out of it, but if you want an alternative, you have to deal with it at the contract stage or at the dispute stage. But the bottom line here is, in the UK, the default mechanism is it's a one-person panel, a judge, an arbitrator, or an adjudicator if you can't agree those. So it always reverts back to the one person. Okay. That's all I said for now. Richard's going to deal with other issues, particularly internationally.
Thanks, John. Over to Richard.
Okay, good morning. Yes, thank you, John, and thank you, Jeremy. There's rather a lot of overlap between what I'm supposed to say and what John's already said. So let's just take everything John has said as read and just move on. There is one thing I'm going to say, because I had this horrible moment of realisation. The Arbitration Act and the Housing Grants Act, both 1996. 1st of May 98, obviously, with adjudication. And for my sins, I qualified on the 1st of September 98. It's also the year the civil procedure rules came in, for those of us who forget, 98. So it's a big year. But the purpose of this is sole or multiple decision makers. And I know it's an adjudication conference, I know this topic goes wider, but I want to talk about judges first when we're talking about sole decision makers. And bear in mind, the one thing I haven't said, I'm supposed to be speaking from the representative's point of view on this, sole or multiple. But before thinking about whether you have one or more, just a reminder that in the court system, we have one judge who determines incredibly high-value cases at first instance. But ironically, if you go to the Court of Appeal, you will get 3 judges. So you have just pros and cons of things, but just so we remember that when you think about courts and whether 3 or 1 is the right thing. As far as the court is concerned, 1 judge is right to start with, but once you have an issue, an appeal, you go to 3 judges to make a decision. And let's remember just how many there are in the Supreme Court as well, as a panel, to when it's a very important legal decision. Anyway, what I want to talk about, of course, is advantages and disadvantages of a sole decision maker. A lot has been said already about adjudication. comments made about adjudicator nomination bodies. I can see a fair number of adjudicators in this room. Thankfully, I don't wish to receive a solicitor's letter like Paul did, so I'm not going to make comments about any particular adjudicator. But there is always a question when we're looking at appointment, as John's already said, about who you nominate or who is nominated. And it does sometimes appear when we're talking to clients that it's quite a closed shop in some nomination bodies. If it's a high value adjudication, you can guarantee there's going to be a group of maybe 10 who will be on that. There's certain organisations, there's sort of cab rank principle that's applied by TEXA doesn't seem to apply. You're probably going to get the same people. Is that because it's a safe pair of hands in the view of the nominating body? Certainly you do question. But the worry I usually have when I'm advising clients as we're about to commence adjudicators is actually cost and the quality of the adjudicator that you may receive, have appointed. And so you look at your nominating body in the contract, you're always advising of that. And then, in fact, I remember, because sadly I was at Fenwick Elliott at the time, there was a case that was done about nomination where a firm of solicitors had on the nomination form only listed 3 potential options as the adjudicator. You could see someone in the audience smiling because it was a firm he used to work at that did it. And around bias. So, and it turned out those 3 adjudicators were all known to that firm of solicitors. And there were some question marks raised about bias and around that appointment. And it's that became quite a big issue, but I don't think that's an issue so much today from our point of view. But we do worry, and I've turned round to clients and said, and the adjudicating question is not in this room, as soon as I've received a nomination, oh dear, that's not the language I used, we're going to get one ridiculously big bill for nothing here. Smash and grab adjudications, and you can tell a client at the end when certain adjudicators are nominated, we're about to get a £20,000, £30,000 bill for a smash and grab adjudication. Batten down the hatches, and I'm not going to say any more, but I can see 2 people going, I wonder who he's talking about. But I can think there's a whole audience full of people wondering who I'm talking about. You all know. There's a group. But so that's the problem for us. There's cost is really important. Single panel adjudicator for us when I'm advising clients and who we're going to get and the nominating body and who's on the list. And if we're looking at a contract to see who's been agreed. I still see contracts when I'm doing at the transactional end where they list a small group of adjudicators as the contractual adjudicators. Now, interestingly, it's the same for adjudicators pretty much every time. There's a list of adjudicators in a contract, one of whom's in this room. So put forward, but usually we don't have a problem because they are sensible individuals, so we're quite happy today. So anyway, moving away from adjudication, moving towards the international sphere, but also looking at arbitration. I took the time, and I think Seamus has shown me some notes, so he'll be talking more fully on this topic. So I'll just be an introduction rather than right over his. But I was looking at what do the various arbitration rules provide for the nomination of arbitrators? Do we have any sort of common theme about single or multiple? Because when you're working abroad, it does seem that dispute boards, 3 parties, arbitration, you have each party nominating their arbitrator, and then you have the chair of the arbitral tribunal who's either nominated by the institution or somehow agreed between the parties, and then you begin to feel in some arbitrations that actually 2 out of the 3 arbitrators have been picked almost to be advocates, extra advocates for your client, a sort of view. Of course, that's not my view, so other people's view that these arbitrators are chosen for those purposes. But you do have that with 3. You're always thinking about who is going to be your party nominee. But I looked at the rules. So the CIR arbitration rules, 2015, refer to the possibility of agreeing a single arbitrator, but defaults to 3 in the 2015 rules, whereas the CMAR rules is single arbitrator. And then also, and this is where I'm going to step a tiny bit on Seamus's toes, but I'm just going to reference the LCIA rules, in particular Article 5.8 of the LCIA rules, that refers to a sole arbitrator shall be appointed unless the parties have agreed in writing otherwise, or the LCIA court determines that in circumstances a three-member tribunal is appropriate. And given what Jeremy said, there's an interesting bit in brackets in the LCIA rules. It says, or exceptionally more than three. So they do actually provide in the LCIA rules for having an arbitral tribunal with, I'm going to assume not four, because you always want an even number for odd number for voting. So that was an interesting one that I was looking at, but looking at pros and cons. And the last thing that I wanted to speak about, because time is pressing, but we're also stalling a bit, I think, for Damien, is to talk about the ICC rules for arbitration. And specifically, the amendment, the expedited procedure that was introduced for, and I think when I said low value during one of the preparatory calls for this, John laughed when I said, I think I actually got the figure wrong, but it was $2 million was a low value dispute as far as the ICC were concerned. And then you have the expedited procedure. Now, I don't know if anybody in this room has had the experience of the ICC expedited procedure. No, good. I have, and actually a member of a panel later was our arbitrator. But it actually works incredibly well, even though we were a German client and regarding a matter in Astan, but it worked for a low value dispute. They've recently increased it to $3 million, and that is a single arbitrator. So that's the cost issue as well, because there is a big cost in the number of tribunal members that you have. Obviously, and just to reiterate the pros and cons that John mentioned, you do have the question about, and I've used to work with a well-known arbitrator in my office, who all the time I would go into his office and he would be going, I'm looking at my diary, I've got to get this arbitrator and this other arbitrator, and how are we going to get our diaries all together, and how am I going to get to Dubai? Nowadays, he lives in Richmond. You can't get him into central London for a meeting, but you can get him to Dubai for a meeting. But then again, that's lunch in London over a trip to Dubai. It's understandable. But it's very expensive. It can be very time-consuming. You certainly couldn't do it in a 28-day adjudication where you're finding multiple people to do it. So those are really pros and cons. No conclusion out of that, but then I think that's what we're going to summarise at the end, and hopefully I've not overrun too much.
Thank you very much, Richard. Seamus.
Good morning, one and all, and Jeremy and John, Richard. I'm going to change it in a slightly different direction now, talking about the international point of view, because we've been talking primarily about UK-based. So really, what are the different aspects to international that lends itself? Well, firstly, a lot of international arbitrations are in, obviously, international locations with international parties. So they're completely different dynamics. So because you may have, let's say, a German contracting company that might be against a Korean company. So what then actually happens is the parties need to, respect international arbitration. Party autonomy is really key because that's where it comes from. The parties that contract internationally. So it's really up to them to govern how the dispute gets resolved. And there's a lot of aspects in that because they'll have potentially different cultural aspects, they'll have different legal systems and the like. So what they actually do is they want to be quite content that the people that they're investing in the tribunal are good, can actually do the job, can understand where their position is. Because, as I say, you need to understand that an arbitration is really only as good as its arbitrators. And the real aspect as well is, given the limited right of appeal in our arbitration, you want to make sure that you've actually got the right people. I mean, and the orthodox view in arbitration, international arbitration anyway, is that you'll have a three-person tribunal. And how that's normally composed, and I'll come on to the rules now in a minute, but how that's normally composed is that you'll have one party will nominate somebody and appoint somebody, the other party will, and then depending on the rules, they'll, let's say the ICC, the president will then get appointed. So, you know, to use a colloquialism, both parties have skin in the game. You know, they're kind of content in the fact that they have people who they've appointed. So they should be more invested into it and therefore give confidence in the process. Now that in itself actually then gives a bit more of a wrinkle in the system, because it has been said and observations made that potentially a party appointed arbitrator or tribunal member might give a bit more credence or try to potentially advocate the position of the nominating party. So there's a couple of issues that you have to be careful with there in relation to that. Bias and sympathy, it said, you know, they may be consciously, they may prefer the party, so they may come off and make many points, but not quite enough just to make it completely warrant their removal from the panel. They may be subconsciously, because they may thinking, you know, again, subconsciously, well, I've been appointed, and so there is that aspect as well. There's also the potential risk that they may feel obliged to make sure they advocate the position that that's put in. And then there's also the issue about their own cultural aspect as well. They may have cultural bias. So there is a concern in that regard. So that's to do with impartiality as well. Now, so I think I've kind of just set out there why international arbitration has three-party tribunals ordinarily. Although the rules, when you delve into them, as Richard says, you know, I automatically think, oh God, they're always going to it's always going to be three-party, but it's not. If we look at the rules, which I had to go and refresh my memory on, there does seem to be a preference towards single-appointed arbitrators, and again, that's probably to do with speed and efficiency, because if we look at the process again, it's difficult enough getting a busy arbitrator to change their diaries if something happens, which would happen during the process. But if you try and herd three people together, or three cats or arbitrators, it's very difficult. I'm just doing an arbitration at the moment as an expert witness, and there's been a little bit of goings on, let's say, between document submissions, and before you know it, the hearing date's moved out 6 months. So that's really, I think, why a lot of the rules do try to press towards a single arbitrator. So, as I say, the London, the LCIA 5.4, sole arbitrators shall be appointed unless the parties have agreed in writing otherwise, or the LCI determines the circumstances of three-party. So again, it's pressing, but I think in my years of experience of working initially as a contracting with international construction companies, a lot of these things are set in the regional arbitration agreement. So when it gets to the likes of the rules, the parties more or less determined what they want anyway. So whilst it may actually be a preference for sole, the parties' requests, again, given the fact that arbitration is at the behest of the parties. If we come to the ICC, again, the ICC is another preference for one. But they can, this is Article 12, where the parties have not agreed upon the number of arbitrators, the court shall appoint a sole arbitrator, save where it appears that to the court that the dispute is such as to warrant the appointment of three arbitrators. So again, one going to three. Whereas the UNICITRAL rules 2021, they take a slightly different approach. If the parties haven't agreed one, then they go to three, which I thought was interesting. The point about in the court system, it's one, and then it goes up to three. So that's an interesting point, because maybe And it's also one of the difficulties with a single arbitrator or decision maker is, well, and especially cases are complex, they may miss something. And if it is an arbitration, the limited rights of appeal, the last thing you really want to do is probably think to yourself, well, God, I should have had 3 people on the panel. It might have been a bit more expensive, but I may not be looking at this, and I may not have had the issues and hassles. I don't know how I'm doing for time.
Another couple of minutes.
Oh, God, okay. Well, so, I mean, so we're looking at, as I say, international arbitration. We're looking then at what sort of experience would we expect in a tribunal? Because if we're going to have three parties, three arbitrators, well, you know, would they have legal industry experience? What's their qualification? Is it a common law, civil law? You know, or is one company from, let's say, the United Kingdom, another company from, pick a common law system, France? You know, are we looking at a matter that's quite black letter, or do you want someone who's a little bit kind of propulsive, someone who might be a bit swayed by a good argument as opposed to the black letter? You know, the language of an arbitration, the cultural background. I mean, I just see here there's a note that in the ICC awards in 2020, there was 80% of the awards are in English. Now, it doesn't necessarily mean that the documents were in English, but again, the cultural aspect of understanding what goes on. And again, it's been said, key attributes of a good arbitrator is sound judgment, virtue, reckless ethics, that they're prepared, responsive. And then we get into, I mean, I'm a QS, so it's always very difficult. I mean, I mainly practice in international arbitration as an expert witness. I don't think I'd ever quite make it as an arbitrator because it's packed with so many lawyers. But that's the general sense of what it is. But there are supposedly, you know, categorization. You could have academics, judges, counsel, and experts, and each of those have their own advantages, and some may say disadvantages, because I have heard it said about judges who go from being the master or mistress of all this very into arbitration. It can be a bit of a murky jump for them. But I think in summary, international arbitration, if it's any sort of size of a dispute, does lend itself, albeit given the cost and the potential time issues, it does lend itself to a 3-party tribunal to safeguard against the mistakes that could be made by one person. And that's all I have to say at them. Oh, and so one last thing is about obviously sharing the burden. The aspect is 3 sets of eyes are better than one, supposedly. So, and yeah, that's it. That's it from me. Thank you.
Thank you very much. Thank you very much. Let's kick around some of the questions that have been raised. So far as expertise is concerned, my own experience has been that there's much more opportunity to pull in different disciplines in dispute boards. And on those that I've sat on, I think most of those have involved at least one QS, and very often an engineer with a speciality focused on the particular project. And that's a very helpful thing, which you rarely see in arbitrations. So that's perhaps one factor in favour of a 3-person tribunal. I don't know if the panellists have any views on that.
Well, I'll hold this a lot further away. I was just actually thinking, as you said that, the one thing we haven't spoken about in too great detail, I know it's a topic of dispute boards, where you're actually more likely to find people with multiple different disciplines to assist the parties in obviously watching the project go all the way through, and they have that great understanding. I mean, from when I've looked at these, I've actually thought when you're having 3 parties, having 3 lawyers is not necessarily like I say, something mildly controversial, it's almost guaranteeing an argument between three lawyers. Whereas if you have people with different skill sets, they will understand the particular issue and can help one another to come to a conclusion. So I can see a lot of benefits to it.
Yes, I think that's a very fair point. It certainly helps with a more collaborative approach. I mean, generally, unless you have a tribunal where one or more of the members is clearly partial and is trying to help out the party that's nominated him or her, which is relatively rare, generally you do get quite a collaborative approach on the tribunal. But I think it certainly helps if you've got complementary expertise and everyone can bring something to the discussion, which is really useful.
Can I raise one point there? An expert should be able to explain things clearly to one-man panel or not, and there's always a danger of educated people use jargon not to explain things but to show they're educated. And so there's a little bit of concern on my part in that a good expert for me can explain to a lawyer, an engineer, a one-man panel what that position is, where it's particularly, for some reason, planning issues seem to be surrounded by jargon. So I accept that, but I'm always wary of engineer talking to engineer, and I like to understand expert reports when they go in, and I struggle sometimes, actually. So a key point is to get the point, if you've got a one-man panel, make sure your expert can get that across really cleanly. And you should be able to explain that to anybody, whether one-man panel is a QS engineer or otherwise.
Yes, I mean, that's bringing up another point, which is that with many experts, they're very expert indeed on their particular subject, but communicating it to an audience who do not have that particular learning, they find very difficult. And certainly from a counsel point of view, an expert witness who's good on paper and is explaining something simply is very valuable. And if you don't have that advantage, so if you have party-appointed experts who don't have that particular skill, it may be a challenge for the tribunal if they don't have the expertise to understand it. Shall we talk about another issue that you've all highlighted, which is choosing decision makers? And with one, of course, you might be able to agree on the decision maker, particularly at the start of the contract. But if not, there is an element of Russian roulette about the choice of adjudicator or arbitrator from the particular institution, which is the nominating body. With three, however, there's more opportunity for choice, particularly because the parties get the chance to appoint a member each, and then indirectly the parties can influence the choice of chair, because typically what happens is that the party appointees talk about it, and they may well nominate the chair if they agree. If they can't immediately agree, they may try to select the chair by giving the parties lists on a blind basis from which they select. So there's an element of choice there. Do you see that as a factor in favour of three-person tribunal? Richard?
Yeah, I was just thinking while you said that, of experience of arbitration and adjudication where you've got a single party. Obviously, the time scales for adjudication help you to agree adjudicator, because if you put forward someone who's deemed sensible, you're quite likely to find agreement subject to their availability. But in arbitration, when you put forward usually three names, you usually put, in my experience, you put forward the three names of people you kind of almost don't want to have. because you know there's more time. So the other side's going to go, do it like those three. Here are my three. And you go, I don't like your three. And that way you've actually excluded all the people you didn't want. And then you get on to choosing one that you'd like between them. But I think from where it's three parties, and having talked to a few arbitrators about how the process is, it's still, sometimes you feel like it's still the old boy network, or old person network, perhaps I should say now, of people you know that you go to. And so, certainly there are arbitrators I'm sure arbitrators in this room, who don't have to look for work anymore. It comes to them because they have a reputation, they're known, they're going to be chosen. Whereas if there's somebody new coming into the area, it can be quite difficult. So I think, well, we've gone off the topic, but I do think that selecting them three parties is helpful sometimes.
Yes. Seamus, I don't know if you want to add anything to that from the international perspective.
No, I think as I set out there, really, it's an international perspective. It's all about the parties having an input into it, that they're not just beholden to someone who's foisted upon them. That they are quite happy that the case that they put forward will be given a proper examination. So I think the whole process of the three-party permits that. So sadly, for sometimes they don't get the result they hope, but hopefully justice is being done, or, well, as justice is. So that's about it.
Yeah. Now, another factor we've talked about is speed. And with typical adjudication timescales, one can see that a three-person adjudication panel, other than a DB set up well in advance, is very, very difficult. And also with emergency arbitrators, setting up three people as emergency arbitrators really isn't practicable. And in practice, all the institutions appoint sole emergency arbitrators. But is there a scope for sensible discussion between parties at the start of disputes to lengthen time scales and thus allow the possibility of three-person panels? I mean, one can see with a typical ambush, smash and grab adjudication, that's not going to happen. But leaving that aside, is the scope for agreement on more time, which would then allow three persons to be appointed?
Well, just taking it slightly differently, I mean, I've seen in UK adjudications where we talk about it being 1 and 28 days. I've been involved in a couple where they've gone on for 4 or 5 months. I'm not aware really of, in the UK anyway, of having an extended time period to allow three people. It's ordinarily to allow their person time to get ahead of it, because parties normally, even these two parties anyway, were experienced and understood that if they got the right person and that right person could manage the process, then it was better than getting better to have a longer period of time and get a better decision than a short period of time and get a dog's dinner.
Yeah, sure.
And it settled afterwards. So I would find it, and maybe John and Richard, in their experience, whether they've actually found a situation where the period's been extended to permit a three-person.
No. I was, when you're saying that, I was thinking, well, and statutory adjudication, how do you? I know you could agree and try and come to it, but I just can't see anyone in adjudication doing it. But it's in arbitration. I was actually thinking on the earlier question as well, one of the key things with nominating your parties is, of course, you will find, and Seamus mentioned this, you will find common law arbitrators being appointed and civil law arbitrators being appointed, because parties prefer to have people for their own particular area rather than the law necessarily of the contract. But back to the point, I can't imagine in my mind, I can't actually imagine doing it, holding back an adjudication because it's only interimly binding to appoint a three-person panel.
Yeah. One of the difficulties, of course, is that at the moment there is a serious dispute. It's difficult for parties to agree, what day of the week it is. So possibly one of the take-home points about this for anyone involved in the transactional side is don't allow the dispute resolution provisions to be the midnight clause. Make sure it's set up in advance with what your particular party wants. Because if there is a dispute, it's going to be very difficult to agree anything.
This panel is why adjudicate first. There is an implicit question in that, which is that there's an assumption that you should do so. We can discuss at the end whether that's actually right, but can I plant this thought right at the start? It does depend what you want, and sometimes there is an implicit assumption that what clients want is a quick, speedy resolution. My experience is that sometimes they want a long, drawn-out, bloody war. Now, why that should be may be a matter of, the risk allocation of the contract, hoping that something's going to turn up, hoping that people will get bored with supporting Ukraine, whatever it happens to be. But one should just question assumptions that what the parties really want is a decision. They may want the opposite of that. They may want a tactical win. They may want to have 42 different adjudications. Now, to discuss these interesting questions, we've got an extremely distinguished panel. It's like one of those pub jokes which are now banned on the grounds of cultural sensitivities and inadequate diversity. But we've got a quantity surveyor, an engineer and surveyor by background, a barrister, well, you've got to have two of one thing, and a solicitor. They are all in their field extremely well known. I think all of everyone here practices to an extent as an adjudicator as well as either an advisor or an advocate and also an arbitrator. We're going to start by dealing with the quantity surveying aspects by background. Dean's going to talk about cost. We're then going to move on with Patrick Waterhouse to time. And then Abdul is going to talk about what started off as being inevitability, but which I think means what the default positions are, what the choices are in various different places. And then finally, Richard is going to talk about the psychology of adjudication. And I'm really interested about that because solicitors talking about psychology really does strike me as being something which I've got to hear. So without any further ado, Dean, do you want to start us off? Do you want to have the... Oh, there's probably one up there.
Okay, good morning everyone. So I'm going to talk about the cost perspective of adjudication and bear in mind that I've been tasked with putting forward the case for adjudicating first, with my main focus being on costs. Therefore, what I've got to say really just represents one point of view, and there could be arguments against that point of view. So 2 points really is that adjudication achieves better cost control and cost certainty, one argument. And another argument is that adjudication achieves reduced costs. So looking at the first argument, that adjudication achieves better cost control and cost certainty. So if we go back to the Housing Grants Construction and Regeneration Act 1996, which was enacted in 1998, it contained no provisions for pertaining to party costs in adjudication. As a consequence of that, as adjudication developed, so-called tolerant clauses became popular, with which undoubtedly many of you will be familiar with. But tolerant clauses are those included in a contract which allocate the party's adjudication costs to the referring party. And they arose from the Bridgeway and Toland case. As a consequence of that, it became fair game to use a sledgehammer to crack a nut if you were the responding party, knowing that the referring party would pick up the bill. So adjudication could have been expensive for a referring party, bearing in mind that it's had its own costs to pick up as well as those of the responding party. We move forward to 2011, when the Local Democracy, Economic Development and Construction Act 2009 was enacted. In that act, Section 108A was introduced to make it unlawful for a contract to allocate parties' adjudication costs. In essence, that meant that the parties in adjudication would bear their own costs in those proceedings. Now, Section 108A does allow the parties to agree after the service of the notice of adjudication that the adjudicator can decide and allocate costs. But in practice, in my experience anyway, actually in over 150 adjudications, not once has that been agreed. Therefore, invariably, the parties' costs in adjudication lie where they fall. That means that the parties can now adjudicate with the benefit of having to concern themselves only with their own costs. They therefore have far more cost control and certainty over their costs in the proceedings than they would do had they decided to not to adjudicate and to go headlong into an arbitration or a litigation. So, in summary, adjudication proceedings, if you adjudicate first, you have far more control over the costs that you will incur and more certainty as to what they will be. So moving on to the other, the second point is that adjudication achieves reduced costs. So there are a number of points in relation to this, and they are arguable, but bearing in mind that I've been tasked with putting forward the case for adjudicating first, I shall look at the positive aspect of that. So arguably, there is far less of a requirement for experts and expert reports in adjudication proceedings because the adjudicator is likely to be an expert or at least very knowledgeable in the subject matter of the dispute themselves. Now, when you apply to a adjudicator nominating body, you set out the brief details of the dispute and what you are looking for from that adjudicator or an adjudicator that they are to nominate. Therefore, you should, in theory at least anyway, perhaps not always in practice, be appointed, or an adjudicator should be appointed who has an in-depth knowledge of the subject matter of the dispute. As a consequence of that, experts are less likely to be needed, although in practice there are parties do obtain expert reports for submission in the proceedings, but arguably that is not strictly necessary, and a good advocate could run the case without an expert report and thereby reduce the costs to the party that they're representing. The parties can actually run adjudication proceedings themselves if they've got the necessary know-how or expertise in-house. This can avoid having to employ expensive advocates, lawyers, quantity surveyors, whoever they may be, and they can get on and do it themselves. In practice, again, that probably only happens, in my experience, in smaller disputes, but the opportunity is there, and therefore that will reduce costs in comparison to those for other proceedings such as arbitration or litigation, where invariably you have lawyers, etc., and experts, etc. Adjudication is a swift process with a decision within 28 days of the referral, which avoids incurring significant costs over a prolonged period of time. As everybody in here will obviously be aware, that litigation, arbitration proceedings can take many months to reach a resolution with many hearings, etc. Adjudication is swift. It's legislated to be done within 28 days. It doesn't always happen, but invariably the idea is to still get a decision within a reasonable period of time if the parties agree that the adjudicator needs some more time, or they need some more time and the adjudicator agrees that they can have it. But it's far quicker than any other process and thereby reduces the costs of the process. Another point is that it's reported that 90% of adjudications they proceed on a documents-only basis. Therefore, this avoids the need for expensive hearings. Indeed, I've represented parties in excess of 150 adjudications, been to 2 hearings, and the hearing that I did attend ended up with 2-3 lawyers from each side. The referring party appointed a barrister, so we had to appoint a barrister. Then they had a solicitor, so we got a solicitor. And it was a 4-hour hearing that didn't really get anywhere, very expensive, completely unnecessary. So that is largely avoided in adjudication. It is invariably done 9 out of 10 times as a documents-only procedure. Another point to make is that adjudicators' fees are generally pretty reasonable, certainly in my experience, and therefore it shouldn't be overly concerning if you were to lose and you are awarded the adjudicator's costs. In my experience, again, in over 150 adjudications, I have probably had 2 occasions where I've received a bill from the adjudicator where I've thought, wow, you know, how on earth have you got to that number of hours and that fee? But majority of the time, complex disputes, the hours that are clocked up, in my experience, have been reasonable, with reasonable rates, and far more reasonable than you would see had you not adjudicated and decided to arbitrate or litigate. In any event, there are now various schemes, such as the CIC LVD MAP and the capped fee scheme offered by UK Adjudicators, which fix or cap an adjudicator's fees in the relevant proceedings. So there is another aspect to adjudication which has been developed over the last few years with a view to making adjudication more accessible to everybody. And particularly on small and medium-sized entities, you can fix or cap adjudicators' fees in particular circumstances. Furthermore, adjudication can be used to obtain decisions in relation to discrete parts of a dispute, thereby avoiding the need to have to refer such parts to costly arbitration or litigation proceedings. So if you have a large dispute, but one aspect of it turns on a particular point, you can refer that point to adjudication, have a temporarily binding decision, and it may be then that the other party agrees with whatever is decided in that adjudication, and it means that there is less then to refer to further procedures that have finally determined. Furthermore, if an adjudicator's decision as to discrete parts of a dispute aids further negotiation between the parties, then it may result in having to avoid to refer the overall dispute for final resolution in more costly proceedings. Or at all, the parties may settle and that's the end of the matter. So although adjudicators' decisions are generally binding on an interim basis only, it is widely reported that in a large proportion of cases, an adjudicator's decision is accepted by the parties and not subsequently challenged by them in a final determination in arbitration or litigation, thereby avoiding the need for more costly arbitration or litigation proceedings. And a final point on adjudication achieving reduced costs, parties can also agree the identity of their adjudicator, thereby perhaps picking somebody by agreement who they know will only you spend a reasonable amount of time on the dispute. It's not going to be excessive. They operate or act at reasonable rates, and therefore it will be a reasonable amount at the end of the day for whichever party has to pick up the tab. And that really, in a nutshell, is the case for adjudicating first from a cost perspective.
Thank you very much.
What struck me a little bit about what Dean was saying there is that of all the functions which we can fulfill here, experts, adjudicators, arbitrators, and so forth, he wasn't even pretending to be independent, so he's plainly acting as counsel in this particular respect. What one would be interested to know is what his expert opinion would be in relation to the questions he put forward, still more what his adjudication decision would be, but no doubt we can ask him about that in due course. Patrick, you're going to tell us about time.
Yes. So one of the alleged advantages of adjudication is time. The question we were given is quite provocative. Why adjudicate first? And the addition of the word first tells part of the story that there is a perception that it might be something you do as the start of a longer process, whereas I think a number of speakers have said this morning already that the vast majority of decisions are either accepted by the parties
or the courts are usually keen to enforce outside of a number of situations like natural justice and jurisdiction. So we're told it's a 28-day process, and in my experience, it's not very often. I'm not a party advisor. I either adjudicate disputes or I teach people how to use contracts properly. So if they don't follow the first bit of my advice, they tend to meet someone like me shortly afterwards. And the adjudications I get involved with, where they're 28 days, they tend to be those falling under the lower value disputes that CIC, TEXA have. The vast majority, I think, fall in 42, possibly to 56 days range. That still, though, when I spoke to a number of lawyers in the last week, because I'm not involved in arbitration or litigation, even 56 days is vastly quicker than what I'm told you would get with another form of dispute resolution. One of the solicitors I spoke to said, don't look at purely the time of the adjudication. When does that party get its money? And he said, even with adjudication, they're still likely to get their money much earlier than other forms of dispute resolution. And I must reinforce, I'm only speaking in terms of the UK today. I've no experience of adjudication overseas. So the courts, we know, will enforce time limits. We're allowed to get things wrong as adjudicators, but broadly speaking, we're not allowed to be late. And sometimes the process is described as rough justice, that you pay now and argue later. And as we've heard today, the arguments probably don't work much later on. And the decisions of courts enforcing decisions, I think, has led to a situation where parties take the adjudication very seriously. We're told, for those of us who can remember, and I must say, although I was working in the industry in the early 90s, I wasn't in dispute resolution, but we're told when it first came in, and I'm predating 96, by the way, because those of you working with NEC contracts in the early 90s will have come across it. We were told it was going to be an informal process, and people complain it's turned into a legal one. Well, if this is your only opportunity to actually secure your payment or to defend a scurrilous claim, then of course you've got to take it seriously. And when I spoke to an arbitrator friend last week, he told me he's got one on at the moment. It's really quite a quick one. He said, we might get to a hearing in about 6 to 8 months. And for those of you who work in adjudication, you'd giggle at that, but he assured me that was one of his quicker ones. And I think the benefits we seem to have as adjudicators are instructing and directing our parties what to do and when to do it. And you've heard from a couple of people this morning about the challenges of coordinating diaries of people who are busy. And that's certainly a challenge, but in adjudication, I always try and get the parties' agreements to extended timetables. But in the event you can't, you have to direct. You have to say, I want that submission by that date. And largely speaking, you get it. We have some parties abusing that position. I've had a couple of Christmas ambushes in my time, one of which I genuinely felt for the responding party. It was a private client, and she was served the notice of adjudication on the 23rd of December at 2 o'clock in the afternoon while she was hosting a family lunch in a situation where, put bluntly, she had not, as we found out several weeks later, she had little to answer for. There is a tactical advantage that the referring party has to timetable, and that, I'm afraid, is part of the challenge. Where people are busy, and typically the good people in life are busy, there are things parties can do, and we have at least one case on file at the TCC where the referring party just pulled out because their counsel was unavailable to take it any further at that point. Adjudicators have to learn to count to 28. Despite what I said about not many cases concluding in 28 days, some do. Some do because, particularly further down the food chain in the industry, people genuinely need their money. And they will not extend it beyond 28 days because they are stretched for cash. They've possibly told their shareholders, their banks, that I've got a good chance of X pounds coming in to this timescale. You ask for more time and they'll just say, no, we must have a decision on a certain date. If you look at Coulson, and always a good thing to do is to quote someone cleverer than you when you want to avoid criticism, he quotes 5 problems with timing. Firstly, and I think someone mentioned this earlier, complex and large disputes. If you're going to spend 5 or 6 months on a high-value, complex dispute worth tens of millions, would you be better litigating anyway? Because the time advantage is starting to evaporate there. The parties need certainty. Coulson describes that as paramount, and I think timing, as well as costs that you've just heard from Dean, I think timing and costs are the 2 big advantages. Parties must reply to requests for more time. Now, there's a number of cases we've seen where adjudicators have run out of time because they've asked for more time and one of the parties hasn't responded. There was one case, I think it's about 5 years ago, with Dennis Baldwin, I think wrote to the parties and said, I need however many more weeks it is, and I assume that you agree unless I hear to the contrary. And unfortunately, he wasn't successful with that. The 28 days, if it is 28, is not a guideline, according to Coulson. It is absolute. And where we have final account disputes, of course, it becomes all the more important you get it done on time. In terms of the ability to count to 28, one situation I came across because of a complaint received by a nominating body was an adjudicator who had missed that the public holidays in the various jurisdictions of the UK differ slightly, and that doing an adjudication in a different jurisdiction to where he lived and worked, he'd missed that there wasn't actually a bank holiday he had allowed for. And so he eventually gave his decision on day 29. It didn't reach the courts, but both parties said they weren't going to take it any further as a result of that. The longer timetables of litigation and arbitration sometimes are justified by the parties doing it because they want what they perceive to be a better result. You've heard from several referring party representatives today what they think of certain fine adjudicators in the industry, and as an adjudicator, I'm afraid I have to agree, and there may be some of you out there thinking he's been a bit hypocritical here, but as Roger said, we can't see who's here at the moment, but I deal with complaints about adjudicators at 2 leading professional bodies, and occasionally we get things put in front of us that are absolutely terrible. So those concerns you might have about the adjudicator may only be in a minority. I hope they are in a minority, but they are real. And the concerns about arbitrators that somebody mentioned earlier, although I've no experience myself, I also picked that up in talking to people last week in preparations for today. The case law separates 2 timings for adjudicators. There's reaching your decision and communicating it. This panel managed to arrange the order in which we spoke between about 20 to 10 and 10 to 10 this morning during the previous speakers, because it was one thing we hadn't managed to arrange in our meeting last week. Modern communications, I think, means there is no excuse for reaching your decision on day 28 and somehow communicating it on day 29 or 30. So I've not received any paper from parties to an adjudication since the start of COVID. I've not asked for any, to be honest. I think all of our communications are electronic. So even though there were some early cases in the TCC about communicating a decision that was reached on time but not sent on time, I don't really think there's much excuse for you communicating it late to the parties. So overall, I think time is the big advantage of adjudication, the ability of the adjudicator to direct the parties in what they do. The time limit was set by Parliament, so you often see people justifying their strict timekeeping because this was Parliament's intention, and of course that does impact upon the way the rest of the decision is reached and the other aspects of the adjudication. Thank you.
Thank you very much, Patrick. One of the things which struck me from listening to what you were saying was it is sometimes difficult to remember just what an enormous change the institution of compulsory adjudication in this country was. It was probably the biggest single interference with freedom of contract in this field for a very long period of time. And if one thinks of the occasions when there's a justification for interfering with freedom of contract, mucking around with the construction industry wouldn't strike you as being one of those. And it is, I think, really quite interesting that there is, as far as I'm aware, no call to get rid of adjudication. And I think that's probably in large part because of what you were saying about the very large number of decisions which are not taken further. And although I'm certainly aware of an enormous number of complaints about adjudications, adjudicators, processes, and it may well be that I see by definition the ones that go wrong, it really is worth remembering that there isn't, despite all of that, I think, anything approaching a call for some kind of, let's just go back to letting people contract as they want to. And with that, we come to Abdul, who's going to talk to us about the default position and where we get to on this.
Thank you, Roger. If I may, with your permission, follow the tradition in the TCC of making my submissions from a sitting position rather than standing. Thank you. Somebody whose name I always forget said there are 3 things in life that are certain: death, trouble, and taxes. If you work in UK construction, I would add adjudication as the 4th inevitability in your life. Adjudication has become increasingly a feature of construction in the UK. So looking at it from the perspective that Roger and I sit at, which is we see things when they go wrong, it is incredible to see the extent to which adjudication has grown since its formal introduction statutorily in 1998, and the extent to which it's crowded out UK domestic construction arbitration, and the impact also had on UK domestic litigation. Now, I think one has to start from the position of looking at things from domestic perspective and internationally. Domestically, of course, we've got the Construction Act, which gives people the right, not the obligation, to adjudicate. And it's interesting to see how adjudication has grown in that context, because I think I was around at the beginning of adjudication, and I can recall that there was some doubt in some quarters about the extent and degree to which industry would make use of this newfound right. And I mean, all of us in this room, I think by definition, we're sort of self-selecting group in that all of us practice in adjudication, so we all know how popular adjudication has become. It has become almost an inevitability in contracts. And there's a good reason for that. And one can see that when you contrast it with the international position. Say for a handful of jurisdictions, in Australia, for instance, where there is statutory adjudication, adjudication is a creature of contract, generally outside the United Kingdom, with a few exceptions. It is a creature of contract. There have been various attempts in lots of jurisdictions to introduce it. I practice a lot in Africa. I know that in South Africa there was an attempt to introduce statutory adjudication, didn't go anywhere. So the UK and a few other countries are sui generis in the sense that they've got adjudication as a statutory provision. In the jurisdictions where you don't have adjudication, you will see the problems that arise from a lack of what I describe as a force multiplier on the part of subbies and main contractors. And I call it a force multiplier because adjudication gives parties a route that is generally quick and generally cheaper than the alternatives, which internationally generally is arbitration, to try and resolve disputes, particularly in reference to one issue, and that's cash flow. The underlying rationale for a lot of the Construction Act came from the Latham Act, also Latham report, where the report commissioned by the government in the late 80s, early 90s, that identified the major problem in UK construction was cash flow. And the UK serves as a useful contrast as I say to other jurisdictions where you do not have adjudication as a statutory right. It's a creature of contract. I hope there are no easily offended vegetarians in this room. I'm going to tell a story that I was told by an instructing solicitor earlier this year who works in a certain jurisdiction in the Middle East. Before going into private practice, he worked as an in-house solicitor for one of the big four developers in this unnamed jurisdiction. And he told me the story about their approach to contractors. Now, this is a very large developer. And he said that the analogy he was told on day one was that you have to look at the contractor as the rabbit, and money is the lettuce. What you do with the contractor is that you give him enough lettuce, so enough cash flow, to keep him alive and stop him going back into his hole. You give him some lettuce at the outset, so he starts to work, and as the works project, you give him a little bit more just to keep him going, to stop him going back into his hole. You get to approximately 80% completion, and you take out a big stick and whack it over the head. That big stick being you call in the bonds. And you stop giving him any more money, you call in his bonds, he's in distress, you then go and negotiate with his subbies directly to get the works completed, and by doing that, you cut out his margins, you get the works done cheaper, and if he ends up fighting you, then fine. It's unlikely he will be able to because he has no money. But if he does, you're looking 2-3 years down the line for any resolution if you go into arbitration, and in that period of time, you had use of his money and had use of the project. That story illustrates one of the major benefits of adjudication to the UK construction industry. It has acted as a means of protecting the cash flow of contractors and subcontractors. Now, prior to the Act in 96 and it coming to force in 98, there are those in this room who practice in those times. And while things may not have been as extreme as in the jurisdiction I'm just describing, it was well known that employers, main contractors, use cash flow as a means of controlling their subcontractors and contractors. And if they felt like it, they just turn the tap off and stop giving them money. And that put the contractor or subcontractor, and frankly speaking, it was mainly subcontractor, main contractor, subcontractor relationships, it will put the subcontractor in a great deal of difficulty. So when I describe adjudication as a force multiplier, which is sort of a quasi-military term, what adjudication has done is that it's given the subbies and those down the contractual chain a different mechanism, a more effective mechanism for achieving a fast, quick resolution of matters which for them can be matters of life and death. I think we mentioned earlier on that there may even be a reluctance to extend the period of adjudication because a subby has given assurances to its bank that X amount of money is coming into my account by so date, and that's how crucial that the issue of cash flow is in the industry. So that has driven what I see as the inevitability of adjudication in the UK industry. The other facet which I want to touch on is the extent to which adjudication has fast become sort of the only mechanism people really use to resolve these disputes. The vast majority of disputes that I've been engaged in, as either as adjudicator or as counsel acting in adjudication, don't go beyond the decision stage. Once you get a decision, people by and large tend to live with it. Even in very large disputes, it's only if there's a particular tactical, strategic reason for pursuing the issue does it then go on to the parties wanting to commence proceedings to try and overturn the decision. So adjudication acts very much as the one-stop shop for, I would say, the vast majority of disputes now in the construction industry, which has all sorts of effects, some beneficial, some not for us lawyers, but that's reality. there is a growing practice now, which is a sort of an adjunct to all of that, which is the use of the Part 8 procedure to try and short-circuit proceedings in adjudication. While you don't get people seeking to relitigate the entire dispute by way of a straightforward Part 7 claim, increasingly I'm seeing parties attempting to use the Part 8 procedure. For those who aren't aware of what the Part 8 procedure is, Part 8 is the provision of the CPR that allows you to have an expedited hearing of a discrete issue that really is devoid of facts. It's really things that are to do with essentially the construction of a document, issues of law. And I find increasingly in my practice that people are trying to use the Part 8 procedure as a means of getting a resolution sometimes during the adjudication. So ongoing adjudication, parties will try and get the Part 8 in to try and resolve the issue or part of the issue the adjudicator is looking at in the courts. Or once they've had a decision, there'll be a discrete issue of law in the decision which they feel aggrieved by, which they'll then try and resolve by the Part 8 procedure. Part 8, let's say, is supposed to be quick, it's supposed to resolve things. It's much quicker than Part 7. And people are turning to it more and more, in my experience, in an attempt to try and get the courts to intervene. Now, Part 8 is, in of itself, it's hemmed in by lots of quite tight, rigid requirements, and the number of times I've had people come to me trying to get a Part 8, and I have to say to them, unfortunately, I don't think your dispute falls within the parameters, and it won't work. So, yeah, I think just to conclude, I think the position that we find ourselves in, certainly in the UK, is adjudication is here to stay. Adjudication is popular. Adjudication serves, in my view, a vital function in the industry. Internationally, it's a different picture. By and large, it's a creature of contract. Parties will use DABs if the contract provides for it. The FIDIC generally requires you to have a standing DAB body. Parties will, because they don't want the cost, will very often not appoint a standing DAB, which can then lead to other problems down the line, which I could sit here and talk for another 40 minutes about, but I won't. Yeah, to answer the question directly, I think, as I said, adjudication, inevitable, and that's a good thing.
Abdul, there's a whole lot there which, if one had time on, would like to pick up on. I did quite like what you were saying about the terminations in the Middle East. I have to say, I didn't think there is another part of the world where I get retained more often, where the project is almost complete and there's a termination. It is quite well known. It is also astonishing how people are surprised when their bonds get pulled, and I do sometimes feel like saying, which part of on-demand bonds did you not understand when you agreed to provide on-demand bonds? And finally, when I look back at the contractors that I acted for in the late 1980s, they aren't there anymore. It does really remind me, risks were taken which were never priced for, and it's like the old joke, how do you make a small fortune in construction? You start off with a large one. A large part of construction problems are because the contract's been underpriced or the risk has been underpriced. And often you've got an overall loss-making project where you're not talking about dividing up profits. You're deciding which proportion of losses should be attributed because the thing for one reason or another was a bad idea. Anyway, that's another whole topic of its own. But what we're now going to hear is the part of this which I really want to hear, which is Richard on psychology. So go for it.
Thank you, Roger, and thank you, Abdul. I mean, I have to say personally, I did like the story of the lettuce. Very topical, of course, and I think possibly quite a large proportion of the room here would also like to have had a big stick. Anyway, that's another story. So the psychology of adjudicating first. I'm a big fan of adjudication. I'll disclose that straight away. I think it's an excellent process, and there's a lot to commend it to parties. But you need to be careful with the process, and you need to manage it. I'm interested in a sort of show of hands in the room. Who, based upon what you've heard so far, thinks that you should adjudicate first? You put your hands up. Okay, so it's probably about 80%, 90% of the room. Okay, how about this question? If you're the responding party and you've been served with the notice of adjudication at 4:30 on a Friday afternoon before a bank holiday weekend, in that situation, do you think you should adjudicate first? Show of hands. Okay, about a few more hands, about 15 hands in the room. Okay. Yeah, I don't like ambush adjudications. I think they should be avoided, personally. First of all, what do we mean by the question? Do we mean, do we adjudicate first, as in, were the parties starting the adjudication? In that case, I think there's a lot to say that you do want to be the party to first adjudicate. And we know that the statistics and the data collected by the Construction Dispute Resolution, Janie Milligan, in conjunction with the Adjudication Society, support the fact that the referring party often is the more successful party in an adjudication process. I think personally that is clearly more to do with the fact the referring party gets to choose the landscape of the dispute. They get to take as long as they want to prepare their case and their evidence to support and substantiate their case. But if we mean, would we rather adjudicate first as opposed to going directly to a final form of dispute resolution, such as arbitration or court litigation, then I still think on balance, adjudication is preferable. As I said, as the referring party, you get to pick the dispute. So you get to pick where you want to go with that dispute. You don't have to have a kitchen sink final account dispute. You can go for the low-hanging fruit on the accounts. So I've got one adjudication in process at the moment where we've targeted an obviously wrong approach by the project manager on an assessment of an interim application where a large deduction has been made, and we've just slung that straight into an adjudication, excuse me. And I'd hope that that would be a 28-day adjudication. We don't need expert evidence. We don't need witness statements. It's a question of yes or no, the deduction could be made. On the other hand, I've also this year had some very complex disputes in adjudication. So to give an example, we had a professional negligence claim against a firm of international consulting engineers. It's very complex, and we referred that to adjudication. Now, the professional negligence claim pervaded the design at tender stage for this large infrastructure project. And we picked off where we thought the most obvious example of professional design negligence was. We packaged that up with geotechnical expert evidence and some structural engineering expert evidence, and we slung it into adjudication again. We had a 6-month adjudication process with a QC or a KC these days, still getting used to that, as our adjudicator. 2 firms of large law firms acting for both parties. It was a 6-month process. The responding party, we knew, and they did, would throw in a lot of legal and contractual arguments as their sort of first line of defence. There were limitation issues, there were issues as to which contract the dispute should have been referred under, etc. We knew all of this was coming, so we had prepared for it in advance. And we got a good decision from the adjudicator at the end of the day. And we got a good decision because we allowed the parties enough time to feel that the issues had been ventilated and aired before the adjudicator in the process. What that led to, ultimately, was us then starting a second adjudication on the next example of professional design negligence. We then agreed to stay the adjudication to allow a mediation, and ultimately the case settled. And that all probably happened within a sort of 8 to 9 month process, with the client getting the money for the whole professional negligence claim in their bank account within 9 months of the starting the process. That's probably twice as quick as you would expect from the courts or arbitration. Technical adjudications, smash and grab, in other words, they are an excellent tool to use to try and gain commercial leverage. You know, they're not very nice because someone's made an error and they've not given a payment notice or a pay less notice when they should have done. But you can sling it into an adjudication, and you can often get a decision, again, within 28 days on a smash and grab adjudication, and that can precipitate a commercial settlement on the final account, or it often happens. You often see it, in my experience, at the end of the project when the QS team have taken their eye slightly off the ball with the payment application processes. What I've seen more recently on that is actually the threat of a smash and grab adjudication has precipitated a sensible settlement. So I had one last week where my contractor client phoned me up and they explained that, yes, they'd not issued the payment notice when they should have done. In fact, it was on 2 projects with the same contractor, so double trouble. And actually the other side, who had the upper hand, made a proposal that my client, who'd not given the payment notice, would simply pay 75% of the applied for amounts. And we looked at the account and we took a view and we accepted the proposal. And it avoided the adjudication, but everybody knew that if we hadn't accepted that proposal, that we would have ended up in a dispute. My client would have spent several tens of thousands of pounds on legal fees, potentially adjudicators' fees, £10,000. It's just throwing good money after bad. So try and get a pragmatic solution. There is a view that adjudication should be used as a forum to test your evidence. I don't think I really agree with that view. I don't think you should ever use a formal dispute resolution process just to test evidence. I think if you're going to engage in a formal dispute process, then you should go into it with both feet, and you should be going into that process with a view to winning that process, or to putting yourself or your client into the best position of getting a settlement out of the process as a result. So I don't really think it's a process in which you should use it to test the strength of your evidence, just so that you know whether or not you'll win an arbitration down the road. Only adjudicate if you're in control of the process. Don't go off half-cocked. Or a story a client told me yesterday, they started an adjudication 5 weeks before Christmas and then were aghast when they had to spend the period between Christmas and New Year writing submissions to the adjudicator. And I sort of explained to the client, well, what did you expect? You know, plan what you're doing, make sure your evidence is prepared. On the other hand, if you do adjudicate, you can't take advantage of sealed offers or Part 36 offers, which you can in arbitration and the court process, litigation. I quite like sealed offers and Part 36 offers as a matter of, again, trying to obtain commercial leverage and to try and, again, achieve a settlement without expending hundreds of thousands of pounds on legal costs. How I have used that, though, in conjunction with adjudication, is to have a quick adjudication on a low-hanging fruit item, get a successful decision, and almost immediately whack in a Part 36 offer if it's going to be ultimately in the courts, or sealed offer in advance of an arbitration. And the psychology of that can often, again, lead to a settlement discussion between the parties. Even if you adjudicate first, if it all goes wrong and you have an adjudicator who's had one or two many glasses of wine or one or two many late nights watching Question Time and not written a well-reasoned decision, which we do still see from time to time, then all is not lost. So if you've adjudicated first and you've got one of those bad decisions that everybody talks about, you can still go to the courts or arbitration. And again, the threat of that with the other side, where the other side may be represented by decent lawyers who know that it's a bad decision, the threat of that referral of the same issue to the court process can still precipitate a settlement. Finally, but not least, I act for a lot of continental European contractors. They are extremely suspicious of adjudication. So, you know, we talk about adjudication domestically in the UK. Parties know what the process is about, and they know and understand that a lot of decisions are just effectively accepted and it doesn't go any further. On the continent, on the contrary, most of my European contractor clients come to me when I say adjudication, and they say, well, what's the point? Because it will just be appealed. I'll get a bad decision. The decision will be rushed because the adjudicator will be too busy. It will cost me £500,000. Why should I do that? And then I explain to them the 7 points I've just explained a moment ago, and they often agree to adjudicate. Thank you.
Well, good morning to you all. We're going now to turn to discussion about dispute boards. Somebody coming from a non-dispute resolution world might be astonished to hear the levels of sophistication that there have been in the speakers so far, and I can tell you there's going to be equal, if not greater, level of sophistication among the panelists, not me. But it's been quite striking how specialist the conversation has been. Before we start off with a discussion about, do you have one adjudicator, do you have 3, then do you go first with adjudication? Is it part of a process? Is it not? And what are the differences between adjudication in the UK and adjudication in other areas? Well, now we're going to add more layers of complexity to this, because we're going to discuss dispute boards, but we're going to discuss dispute boards from the perspective of a number of different jurisdictions. And we will be also hoping that now you've all had a cup of coffee, you will all be awake and therefore willing to receive a roving microphone and give us the benefit of experience from the audience as to what you've experienced with dispute boards, pro and against. But we're going to start with some minor interruption of that process, but with some, each of the panel is going to say a few words about their experience in very different jurisdictions. I'm going to start with Kailash Dabir Singh, who is coming from Mauritius. He's had an extraordinary career, engineer, then quantity surveyor, then barrister, first of all starting in this country and working in industry, and then moving back to Mauritius, where he acts as a dispute adjudication board member, and he's actively promoted, I think you'll gather, promoting ADR in Mauritius, and he's the current president of the SCL Mauritius branch. And he's going to tell you about what are really quite exciting developments about dispute boards in Mauritius. Thank you very much, Kate.
Thank you for this nice introduction, Chairman. Ladies and gentlemen, good morning. Yeah, indeed, I come from Mauritius, and this morning I'm going to talk to you about the way we do dispute adjudication board in Mauritius to resolve disputes. Just to put everything in context, now, Mauritius is one of the most competitive and successful economies in the region. It is recognized for its stable and democratic government, well-diversified and dynamic economy, fairly well-educated population, and a strong legal environment. Now, as in all emerging economies in recent years, all aspects of construction processes have become increasingly complex, technically, legally, financially, in speed, and in size. So it's no wonder disputes have become a natural part of any commercial transaction. So they are part of the activity of commerce itself. So how did the construction industry in Mauritius operate? So the construction industry community in Mauritius recognizes that it is beneficial to acknowledge the existence of potential disputes and conflicts from the very beginning of any contractual relationships. It's a bit like crime in a society. We realize that we cannot prevent crime, but we can deal with crime in a very effective and in a very, very effective manner. And this vision has, to a large extent, been very illuminating and indeed very inspiring. So what the business community, the business construction community was looking for, it was a way to reduce the frequency of disputes, to make their settlement less contentious, and to shorten the dispute settlement period. Not only as a matter to reduce the cost, but also to increase the confidence of the investors. An important feature that we did not neglect or ignore, we realized that no dispute resolution method can deliver in equal measure a just, a quick and cheap outcome, because almost certainly it will be an illusion to look for one. So what we realized that the best method of resolution of any construction dispute is arguably the avoidance of the dispute altogether. So the construction industry has been very fast to recognize and emphasize the important role of dispute adjudication board before any dispute can arise in an endeavor to avoid disputes altogether. Now, although we embrace that concept of dispute adjudication board, there are two important issues that I would like to highlight. First of all, contrary views were strongly held for the proposed adoption of dispute board in Mauritius. The opponents of dispute board raised the fears that its adoption will just represent an additional layer of cost. The die-hard conservatives felt that a fine-tuning of the contract would suffice. And others argue that dispute board would undermine the powers of the engineer and should be dropped altogether. And the second issue was we had a technical and a cultural one. A technical issue, where do we get the dispute adjudication board members, if at all we adopt the dispute board concept? But the turning point has been a series of systematic failures of our public contract. Our contract was marred in never-ending complaints of spiraling cost and ever-ending delays. So dispute board, in the context of dispute resolution, is a relatively recent concept in Mauritius. They are essentially a creature of contract, and the FIDIC conditions of contract is widely used in the country, and it makes room for the appointment of a dispute board at the commencement of any project. But before I go any further, I talk very briefly about the legal framework under which the contract operates. Now, in Mauritius, we have a legal system which is a hybrid one. It's a hybrid legal system which draws its inspiration from France and England. It combines both the civil and the common law practices. And that duality of concept which characterize the law is deeply rooted in the very history of the island. We were a French colony until 1810, when the British took over, obviously by force. So what I want to say, the French code of the civil procedure coexists with the English civil procedure rules. And over the years, as far as the substantive law is concerned, the British introduced a number of Anglo-Saxon concepts. So there is a predominantly Anglo-Saxon legal culture. So until very recently, when it comes to war in the construction industry, the choice of the two principal battlefields in Mauritius lies starkly between litigation and arbitration. Over the generation, a particular culture has grown in Mauritius, with parties resorting at an early stage, almost as a matter of course, to lawyers. So what has happened? A single professional group has come to secure a virtual monopoly of control over dispute processes, but through no fault of their own. I think most of you will agree, lawyers generally approach disputes in a distinctive way, with only one approach to business disputes, the path towards the court at an early stage. Now, it is a matter of legitimate pride that we have an independent judiciary to resolve disputes. But for the litigants, going to the court has something of a toss of a coin about it. All that is certain, that it is unsettling and an expensive procedure best to be avoided. And when it comes to the other battlefield, which is arbitration, it was not regarded as a recognized field of practice. Until a decade ago, it played a very limited role for the resolution of disputes. And the very limited use of arbitration was not only a technical issue, but also a cultural issue. But all this has changed over the last 10 years, and arbitration has become a specialized field of practice. But, there is a big but, efficiency, cost, and expedition, which are generally regarded as a significant benefit of arbitration, are seldom being achieved. So the often touted objective of arbitration are not achieved. And although the outlook and working method of arbitration and litigation are different, they were considered entirely as the two sides of the same coin. So the increasing dissatisfaction with arbitration and litigation has given rise to a movement away from the classical form of dispute resolution. That is a movement away from the judge in the court, and a movement away from the arbitrator in his chambers. So the disenchantment with arbitration and litigation is the main reason for the emergence of Dispute Adjudication Board in Mauritius. And at the very heart and central to this mechanism is the demand in management specialists, in dispute management specialists, rather than dispute resolution experts. Now, there is a distinction which I would like to make between the dispute management specialist and the dispute resolution expert. By dispute management, I mean two things. It encourages the parties to engage in discussion. It means effectively, it means dispute avoidance. And secondly, it means that where the parties cannot avoid falling into disputes, they will enter into a structured process involving a third party for the formal decision. So Dispute Adjudication Board work in Mauritius. And a very good example of this was the construction of a recent hospital, where I happened to be the Dispute Adjudication Board member, and I was the sole member. And the value of the project was about 40 million USD, but in the Mauritian context, it represents a huge sum. So on that particular project, the DAB, the Dispute Adjudication Board, was rated as a substantial success. So in the course of the process, the role of the parties, their advisors, and the dispute board member, they were very cooperative rather than purely confrontational. So the DAB was able to issue advisory opinion rapidly, which allowed the project to continue with very little disruption as possible. And the provision of informal assistance before any dispute arises were of immense assistance. The other project where the dispute board had substantial success was the construction of the international airport recently. Now, obviously, on a project of this magnitude, it was a fertile ground for dispute to arise, but the Dispute Adjudication Board was perceived on that particular project as an organ of the project itself. The structure put in place was able to sniff out the potential conflict before they developed, and the dispute board was only required to issue advisory opinion. What we observed that one of the biggest advantage of the procedure was that it had real-time value. And by real-time dispute resolution, I mean that there was a mechanism that was put in place that could prevent disputes during the currency of the project. And the parties to the conflict were able to take full advantage of the knowledge of the project team and the team members in achieving a resolution of the contentious issues as they arose under the contract. The third and last project where we had dispute adjudication board was the construction of a new security prison. And the low number of dispute board decisions for a project of this scale and complexity provides a convincing endorsement of the effectiveness of dispute board in avoiding disputes in the country. So it is clear that the use of dispute adjudication board in Mauritius is not simply another ADR device. It represents the emergence of a structural change aimed at the prevention of disputes. And why I say there was a structural change, because the attitudes and the behavior of the parties who are involved in the resolution of disputes change significantly. So there is the creation of a wholly new attitude in the way parties perceive their disputes, the way in which they relate to one another, and the way they act in resolving the disputes. And experience also demonstrated that it encourages open discussion. So the early resolution of disputes greatly help maintaining a good working relationship. So to conclude, we realize that over the years, the construction industry dealt with the resolution of dispute for arbitration and litigation. Both processes have played and will continue to have an essential role, but in a very diminishing proportion. Neither arbitration nor litigation is truly innovative. And arbitration is no more a refinement applied to a system that has been used for hundreds of years. So as business becomes more sophisticated, the emphasis is on dispute management in contrast to the traditional dispute resolutions. So the dispute adjudication board model appears to be a worthwhile candidate for consideration. But there is one last point that I would like to make before I finish. So there is a big debate in the country which is raging. Where do we get the dispute adjudication board member? And how far and how fast we will run with the dispute adjudication board is another debate. Thank you.
Thank you, Kailash. But as I commented to Kailash earlier, there'll be a queue around the block to tell him where he can find the adjudicators. So please make an orderly queue. Next, we're going to have, I think we can count that as Mauritius put a big tick in the box for dispute boards. Next, we're going to have Adrian Bell of the well-known law firm CMS McKenna, who has very extensive experience of DABs in South Africa. There may be a number of people here who are very grateful to the politicians in South Africa for creating quite a lot of chaos in the power station business. And I think Adrian has helped to bring some control to that, or not, through dispute boards.
Thanks, Roger. Good morning, everyone. At least I think it's still the morning. Roger asked us to come along and speak to you today to give a bit of background to our experience on dispute boards and then try and make some reflections on why they work or what we could do to make them work better. As he said, my experience with dispute boards is largely in Africa and the Middle East, and those of you that will have worked in the Middle East, historically at least, will say, well, why are we doing dispute boards in the Middle East? Because the first thing you do when you get a FIDIC contract is strike out the dispute board provision. But I think historically that's certainly been the case, although more recently I think there's a growing popularity of dispute boards in the Middle East, particularly because there are more longer-term relational contracts. PPP, for instance, is gaining popularity in the Middle East, and hopefully as a result of that we'll see further endorsement and further use of dispute boards in that region. What I'm going to do is try and promote to you a recipe for success of dispute boards, and I'll be very interested, if time allows, to hear people's reflections on why they agree or disagree with me. I think the best prospect of making a dispute board work is to have a standing board. People will appreciate the differences between ad hoc and standing boards. The standing boards are where the dispute board is in place from the outset of the contract. I think you need to have 3 people on the dispute board. I think they stand a greater chance of success than a sole dispute board member. And I think you need to make sure that you have a very carefully composed dispute board. We discussed this as a group when we were preparing for this session. I think the consensus was that you should have a legally qualified chair usually, but you should also make sure that you've got sufficient range of expertise. Probably the second or third member would it be a technical person and a quantum person. I can say you can have a legal chair because I don't sit as a dispute board member, so it's not turkeys voting for Christmas. I think you do need someone who has some familiarity with the local governing law of the contract and is familiar with the regulatory regime. So a standing board, 3 people, a good mix of people on the board. Obviously, one benefit of having the standing board is that they should have the familiarity. They need to be proactive. They need to be visiting the projects regularly, probably monthly. I think one benefit of that, or one maybe not so obvious benefit of that, is that when the dispute board process starts, it's usually a shorter process because you don't have the dispute board getting up to speed in the same way you would have with an ad hoc process. And having the standing board in place means that the dispute board is normally more inclined to get on with a quick process. And I think if you are going to have a successful dispute board process, it needs to be quick, it needs to be dynamic. Again, we were discussing this amongst us, and I think, most of the time when people say dispute boards haven't worked, it's when they've turned into a kind of quasi-arbitration process where it's been drawn out, it's taken many months, there's many rounds of submissions, cross-examination of experts, cross-examination of factual witnesses. So I think part of my recipe for success is to avoid that happening, to keep a fairly short-form, dynamic, quick-moving dispute board process. And I think, as I said, you need the right composition and you need a standing board to do that. I think you also need to make sure that you have the stakeholders in the project brought into that. You need the parties to fully embrace the dispute board process. It helps to be able to do that from the outset. The dispute board members have often quite a challenge on their hands to build the trust and the rapport with the parties, but I think it's essential that they do that from the outset and they maintain that. The site visits are often very helpful because it continues and enables them to develop that rapport as they go along in the anticipation often of a dispute arising at some point. And obviously you've got the other stakeholders, the funders, depending on how the project is procured. A lot of these other parties that are interested in project will have be very interested in the dispute board succeeding and will give authority and confidence to that dispute board. I think, how do we encourage dispute boards being used more often? How do we give them more teeth? I think if they're going to be successful, they need to have some teeth. They need to have proper authority on the project. Again, getting them involved from the outset, adopting them early on a project, making sure that they're part of the project team, they're integrated. As I said, the success of the dispute board will depend on the ability of the dispute board members to gain the trust of the parties and that rapport very early. And I think applying them to use their broad range of experience. If you've got a legal chair, a technical and quantum people in the mix as well, then make sure you're using the full range of the dispute board's experience. You know, it's there for a reason and it should be optimized. And make sure that dispute board, as I said, is making some very quick real-time decisions. The last thing, we've mentioned this, and I think many people in the room will hopefully agree that we do need the dispute board in the same way that adjudication does to be used during the currency of the project to unlock those issues and to prevent the parties becoming entrenched or bogged down in parties in particular issues. The other thing I was wondering is, can we give them more of a prominent role? Can we give them more authority? We see a lot of bond calls, and I think one quite interesting concept I've seen recently is, writing into the bonds that you can only use the bond, you can only call on the bond when you've got a dispute board decision. So again, that's another way to give the dispute board the authority that they need. Hopefully I've caught up a bit of time, because I'm really interested in hearing from people whether they sort of agree with that proposition that I've made about those recipes for success. And I think Scott's now going to talk about some various tactics and other things that you can use when you're involved in the dispute board process itself. Thank you.
Yes, next up is Scott Stiegler from Vincent Elkins. Scott has had experience in the Middle East and in America on a rail infrastructure project, but I think most of his involvement with DABs has been in a big infrastructure in Central America, which can't be named, probably people will guess who it is. And so he has enormous experience of dispute boards in relation to vast infrastructure projects. So,
thank you, Roger. I suppose the first point I wanted to make is from your opening remark about sophistication of this board. I am Australian. I lack that inherently. So with that, as Roger has said, my experience is predominantly in larger infrastructure projects. What I have seen during my experiences, and these are my experiences alone, and I appreciate everyone has different experiences, is everything from disputes that have been resolved on the paper right through to mini arbitrations. And I get asked the question, and funnily enough, it's the question for this panel, why do dispute boards work? And should the question be, could they work or do they work? I'm taking two of Adrian's points just a little bit further, and I want to talk about what the parties agree the role of the DAB will be, and then looking at the parties themselves. So, looking at the role of the DAB, Adrian's put a persuasive case forward for a standing DAB, but whatever way the parties wish that to happen, we go back to the first principles that this is a creature of contract. And it's not only something that needs to be prescribed in the contract, but also needs to be educated to the DAB so they know what their role is. And there is sometimes a tendency for that role to be blurred, and their primary role is to adjudicate disputes. But when you have a DAB that sits for the life of the project, you get this natural tension between, are you a dispute resolver or are you a problem solver? And the two are not the same. So take the very typical example, the contractor is running out of time, running late, needs more money, but you hit a point in the project where by not awarding time or money now, because of cash flow issues, the project is in peril. A dispute resolver ought to deal with the dispute under the terms of the contract and the governing law, and to make a decision. That is its primary function. A problem solver may look beyond this and seek to find ways to render a decision that grants time and or money. That solves the problem, but does that resolve the dispute? Ultimately, 9 times out of 10, the parties end up in arbitration anyway, so you can see a DAB member thinking, I'm doing my bit for the project by passing cash through, it'll all be sorted out in the end. This is a natural tension and something I've seen a lot through my experience. When you look at the changes in the FIDIC forms as well, this sort of new emphasis on being more actively involved. Obviously, you could get an opinion on the 1999 form, but being more involved, being more in front of the parties, being able to raise questions with the parties and to say, guys, I think you should ask me for an opinion. Does that change the role of the DAB? Is that for the parties, is that the right thing to do? To discuss. The second point is, unsurprisingly, the parties themselves. I've never practiced in Mauritius, but it sounds like a wonderful place to be. Everyone gets on there. So again, my experience is what I typically see. You see either the sophisticated contractor who knows exactly what they're doing right from the very beginning and seeks to game the system. Right to the other end of that, you get the parties who have no experience at all, might not even know there's a DAB process in the contract, and at the very end, they end up in a dispute and realise they've got to go through this process and they've never done one before. We all love sharing war stories. We've been talking about getting the adjudications dropped on a Friday afternoon. I had one dropped on me when my son was coming home from the hospital for the first time when he was born. So, bitter experience. Gaming the site visits is something I see a lot of. The DAB will come for its usual site visits, usually regularly, sometimes at key intervals. And this serves as an opportunity for the DAB not only to see the project, but for the parties to take advantage of that. And an experience I've seen is, unfortunately, quite a wonderful set piece where the DAB was taken around a project. This project was in the Middle East. And the DAB was taken around, and there were ground conditions that were suddenly present at the site. And the contractor, in this case, was taking the DAB around saying, look at this, look at this, look at this, all these problems. Obviously, then the claim comes. DAB is prejudiced by that point. So that's one example. Again, I'd like to hear what other people have seen and what have done. It's certainly not a tactic that I would use personally, because guess what? DABs end up in arbitration 9 times out of 10, and the evidence is admissible. So do these guerrilla tactics work? I don't think so. That's certainly not how I would want to operate things. Again, circling back to Adrian's sort of key themes, why do they work or why could they work? It really depends on the parties and the framework you set in place. They have great benefit where you don't have an adjudication scheme. They have great benefit if you have a discrete dispute you might want to raise or deal with something on the papers. There's great advantage to that. Where I see it falls down slightly is where you have parties who are misbehaving, parties who don't know the process. They don't really engage in the process. Levelling up, which was a comment that was made this morning. Usually it's the parties, and one party might get an expert, another party might get an expert, we might have counsels, and guess what? You're in a mini arbitration. And typically, scale is always a big factor. The bigger the disputes they get, more likely lawyers get involved, more likely experts get involved, more likely the DAB process starts to grind to a halt. And unfortunately, while they do serve a very good initiative during the course of the project, typically we see them fail towards the end. Parties go, thanks guys, we've had enough. Let's go to arbitration and let's put the gloves on and let's go. Those are my experiences alone. I'd love to hear what everyone else has to say. Thank you.
Just before Ian comes forward, I don't want to get too gloomy about dispute boards. I had a lot of experience quite a long time ago when the new airport, what was then the new airport in Hong Kong, was being built, where the Hong Kong Airport Authority was immensely creative in what they did. They had a very proactive dispute board process, which did get rid of, 70, 80% of the disputes, the potential disputes, along the project. They then moved into start of arbitration. They then had very creative mediation of a sort which you don't see very often, which was sort of like a mini arbitration, but they would set aside 2 weeks, and they'd say, okay, quantity surveyors get together, engineers get together, lawyers, keep out of the place, you can come back in due course. And that settled, I think, every single one of the major Hong Kong airport disputes, except for one, I think, in the end. So it is a process which can work. But anyway, now from a different perspective, Ian Nicholson from Ancura is an architect, qualified not just in the UK, but also in Germany. He's now an independent expert dealing with high-value ICC arbitrations, and also he's on the Chartered Institute of Arbitrators Dispute Board and has experience as expert and as appointer and as a member, I think. Yeah.
So, hello everyone. What I want to talk about today is the experience that I had in South Africa on a major power project where I was working as one of 4 case managers managing the dispute board process essentially from the government side, so from the side of the power utility. On our desk at that time, there was something in the order of 40 referrals or potential referrals, and we were keeping an eye on the development of these. Now, we had a mixture of standing boards, ad hoc boards, and we had, more interestingly perhaps, a number of really quite bizarre mutations or hybrid forms, essentially where the standing board wasn't really standing but was waiting for something to happen, or the ad hoc board was so good or so busy that they were being called essentially to stay around for the next dispute. So there's quite a lot of chopping and changing going on. But the project was characterized essentially by an enormous backlog of contract administration. There was a lot of uncertainty, there was a lot of tension, a lot of entrenchment, and ultimately stalemate. So what we were experiencing, both from our side and from presumably the contractor side as well, was essentially that the dynamic of the contract administration had been lost, and the project, and that's actually the important thing amongst all of this, the project had actually lost momentum. So how did this happen? Well, essentially what we were seeing was that the parties were avoiding making DAB appointments. So somewhere in the contract they'd actually agreed to have a DAB, but they hadn't got round to, or didn't want to, or didn't know how to actually make the appointment. When they did make the appointment, they tended, for whatever reason, to find people who had actually very little availability. And that was compounded in terms of a lack of availability once it became 3 members that needed to coordinate their diaries. Partly because of cost and partly because of that problem, the standing boards were avoiding site visits. That's partly due to the location of the project relative to where the project's teams were. So there's various reasons for that. Then the parties were investing, in the literal sense of the word, into taking things to the 20.4 decision, very sophisticated claims, all the things that we've been discussing on opposing experts, on counsel, and so on. The whole thing was essentially becoming much more like an arbitration. So when the parties eventually got to in front of their DAB, the DAB was behaving like they were arbitrators, and it was an arbitration. So in terms of the effort, the costs, the timetable, the behavior of the parties and the decision makers, it was essentially looking more and more like arbitration. So what was happening was, yes, they had dispute boards, but what they were trying to do was move out the decisions, push them out almost to a point where it was going to become finality is what they wanted, simply because they'd invested so much money and so much time trying to get to that decision-making process and ultimately a decision. So from this, I think one of the lessons would be is to really understand what the DAB can and should be doing. So on one side, we've got what in the FIDIC contract would be the 20.4 decision-making process, essentially akin to adjudication, but on this international format. These decisions tend to be made quite late in the game. They tend to be quite paper-orientated because the events are long past, and it tends to be a very adversarial process. To go beyond that, you're essentially looking then at arbitration, and ultimately, in some cases, the only real difference to arbitration is finality. On the other side, and this is something that we came across on absolutely no occasion, was under the FIDIC contract, you could ask under 20.2 jointly for the dispute board to give you an opinion. Now, if this had been used, it could have been used early. It could have been much more a people-orientated thing, so people were getting involved and really working together. And it probably, I think, would have been a much more inquisitorial type of arrangement where the parties would have worked with the dispute board in a much more collaborative sort of way to essentially get to a sensible procedure, a sensible document, complexity, and so on, so that they could actually get to that opinion in real time, or as near as practically possible. To go beyond that, in terms of getting an interactive real-time decision or support, or in the 20.2 case, the opinion, the only way to go beyond that would really to go into mediation. And the only real advantage of going to mediation would have been that you could have had separate meetings with the parties. So two very, very contrasting facilities essentially through the DAB, but what we were seeing certainly in the project I'm speaking about today was we were only seeing this 20.4 decision process being used. So in terms of how to make the DAB work, I think the answer to some extent is in the title. You get the DAB to work. So the first thing you need, I think, is the standing board. Now, for a long time in the FIDIC contracts, it was only really the Red Book that had the standing board. On some of these projects, certainly this project I'm thinking about, there was enormous outdoor works being done where some of it was employer designed, so Red Book, some of it was Yellow Book, contractor designed. But the reality was that the standing board was really necessary under both contracts. At the time, that wasn't really what had been envisaged in the FIDIC contracts. That's now been updated. So the standing board. I think then the courage to make the appointments from the outset and to actually genuinely carry them through so that the standing board can actually stand. To really check genuinely that the availability is actually there in terms of the availability between the board members. Do they have time booked aside to be able to work together as the DAB? And do they have real ability and availability to come to site and to be involved in whatever unfolds? So I think some cases then that means that much as the parties want the absolute A-grade people, sometimes the more local alternatives or the less experienced practitioners may actually be helpful simply because they are likely possibly to have more availability. The other thing that would have helped enormously in the situation in South Africa, I think, is awareness that this 20.2 opinion procedure actually exists and the willingness to actually engage with it and to use it actively and frequently. And there shouldn't really be a problem with doing that, because if you've chosen a DAB that has the right skills and the right experience, and they are your choice of people to be your DAB, then you should actually be able to trust their opinion. So the logic is then, if you can trust their opinion and you value it, why don't you ask for it? So that comes then to giving the DAB the mandate, because they can only act essentially under the authority that's given to them by the parties. But not only the mandate, give the DAB the incentive or the encouragement to actually focus the process and focus the submissions that are going to be exchanged and focus what they need to see. I mean, they should be very experienced people who are very familiar with that type of work on these type of submissions. They should be able to help you enormously in actually cutting the costs and making things really get to the driving points as quickly as possible. Above all, you need to keep the communications open between the members of the DAB, but also between the DAB and the parties, and keep them open at all levels, because some of these decisions and processes, particularly on these very large projects, are almost at board level or CEO level, and very senior government figures. So these communications at all sorts of levels are enormously important to keep everything moving. And keeping things moving is ultimately one of the reasons that the DAB is there to start with. And then certainly in some jurisdictions, and primarily international jurisdictions, it's very important, I think, to have a genuine without prejudice route open as well. There are some jurisdictions that don't really understand without prejudice, and there is a tendency, I think, certainly from UK-based people sometimes, to assume that there is a without prejudice route everywhere in any event, and that's, in my understanding as a non-lawyer, is certainly not the case. So it's all about communications and getting your DAB to really do their job. You sign them up, you're paying for them, use them. Thank you.
Good afternoon, ladies and gentlemen. Welcome to the graveyard slot. When the organisers told us that we were going to be talking about governing laws straight after lunch, I thought it was some kind of joke. And that suspicion was confirmed when I was told my speakers were going to be an Englishman, an Irishman, and a Scotsman. The joke, I think, backfired because our original Englishman had to drop out and the organisers had to stand in to fill that slot. So we're going to address something loosely resembling governing laws from the perspective of those different jurisdictions. And as we're just back from lunch, I thought I could start with a joke. 3 lawyers met in a pub for lunch. 2 of them produced sandwiches from their briefcase. The Englishman was horrified. "You can't eat your own sandwiches," he cried. The Irishman and the Scotsman looked at each other and shrugged and swapped their sandwiches. What a promising start. I'm going to invite my panel to introduce themselves. Dean needs no introduction, so he has a blank sheet to talk to you from the perspective of the Englishman.
Thank you, Kim. I'm going to share some reflections as an Englishman sitting as a tribunal on governing law. Just to let you know, I'm standing in for Charles Brown. Charles did a paper. I'm not going to read it. I'm not familiar with all the contents of it, and I wouldn't do it justice. But he was going to look at the comparative benefits of adjudication in the UK, and his premise was that we're extremely lucky in the United Kingdom because the Construction Act allows us to refer any dispute, not just a payment dispute. And I think that marks out the United Kingdom from most of the other jurisdictions with statutory adjudication. He's got some wonderful quotes in here. I'm not going to try reading them out of context. It wouldn't do it justice. Though in closing in his paper, he mentions what the Supreme Court observed. It is a conspicuously successful addition to the range of dispute resolution mechanisms available for use in what used to be an over-adversarial litigious environment. And of course, that's referring to adjudication. So, would anyone like to tell me what governing law is? I know we've got some very prominent lawyers here. Is anyone awake and would like to volunteer what governing law is? Shall I pick on someone? No? All right, I'm not going to embarrass anyone. I think you all know what governing law is, so I'm not going to dwell on that point. I'm going to kick off talking from my own experience. I'm sure, like most English-trained and qualified tribunals, I don't need to be told what English law is or what it means by an expert, whilst it may be helpful for me to receive legal submissions during the course of the matter. I certainly don't need a professor, barrister or solicitor to appear as an expert on English law. If I sit as an adjudicator appointed by an English AMB for a matter in England, I'm aware that no matter what governing law is stated to apply, you can't contract out of the provisions of the Construction Act. It's territorial in its application. And I'm sure you'll all be aware, section 1047 says this part applies whether or not the law of England and Wales or Scotland is otherwise applicable in relation to the contract. Thankfully, I've not had many English adjudications where a foreign governing law has been the governing law. And when I say that, I've had experiences of Scottish governing law, Irish governing law, but I haven't had any of the civil code jurisdictions. I'm going to touch upon that later on in my talk. I infrequently have had adjudications in England with a Scottish governing law clause. Similarly, I've had adjudications in Scotland with an English governing law clause. This is primarily because the parties were using their standard form contracts and hadn't given sufficient thought into the governing law. You know, it could be a Scottish contractor who's normally doing work in Scotland, and then he's passed that down to the contractor on a project in England, or subcontractor, which isn't always advisable. What I have found, though, is that the parties representing themselves often don't understand or know the governing law, but muddle on free. Those parties that are using lawyers will rely on their legal representatives to point out what they need to know in terms of the law. Those types of adjudications haven't been a problem for me so far in my career, though one day they may be a problem. I'm sure you're all aware and recall a recent case of Multacus Construction and Paolo Castelli. In that particular case that went to the TCC for enforcement, there was a governing law provision of Italian law. It went through for enforcement. It was enforced. I'm not going to tell you about the case. But if I'd been the adjudicator in that case and the parties hadn't used a legal expert, I would have probably looked to use my own legal expert to explain to me what the ramifications of having Italian governing law was. We're very lucky, both the Act and the scheme give the adjudicator the power to take the initiative in ascertaining the facts and the law. Similarly, I can decide to utilise an expert, legal advisor or assessor. The only condition upon me doing that is giving the parties notice of my intention. I do not have to ask them for permission. I give them notice. I can do that if I think it's appropriate. What I have found, though, in my career is where matters become extremely complicated is when you're sitting overseas. If I'm sitting as an arbitrator, the parties appearing will usually lead with expert evidence on governing laws where necessary, and this will be extremely helpful for myself and my colleagues who will not often be from that country or region. This is, of course, in addition to oral and written submissions. A different problem, though, which I've found, is when I sit as a dispute board member. Quite often the parties don't have legal representatives, and based on my own experience, rarely feel the need to make adequate submissions on what the implications of the choice of governing law are. Similarly, they don't call expert evidence in support of those submissions, which is extremely unhelpful to a tribunal dealing with a governing law they're not familiar with. The last thing you want to be doing is trying to get an English translation of a civil code and then believing that you're going to actually correctly apply that. It just doesn't happen in the real world. In terms of the FIDIC contract, the 2017 form with the FIDIC Red Book provides that the contracting governing law shall also apply to the DAAB agreement. What's unhelpful is that they say, if I'm appointed as a DAAB, at the outstart, I have to agree with the parties, my fees, and also I have to agree the remuneration of any expert whom the DAAB may want to consult. Now, quite often, if a board's a standing board, you're not going to have opportunity or know what disputes are going to come out. How can you possibly agree what expert you're going to use and remuneration for them? You just don't know. You're appointed as a standing board. I think it's important to highlight this anomaly because it does cause issues. The procedural rules that are in the 2017 form provide I can use a legal expert, and as I touched upon, with the approval of the parties, and it's in the powers of the DAB. The biggest issue that I find in that type of environment is that parties usually by that time can't even agree the colour of ink in a black and white document, which means they're not going to agree when you say I'd like to call an expert. So it almost defeats having that provision in there. In the United Kingdom, I think we're extremely lucky we've got the provisions of this scheme, which is totally different to the way that FIDIC have decided to set it out. I can give them notice and call an expert. And what I want to emphasise is that parties and their representatives must give consideration to expert evidence where an issue is impacted by the governing law. If you get an Englishman, it is likely they will allow matters to progress on an adversarial basis, and the burden will lie with the party to support the assertions they make. So, if you're involved, different governing law from your tribunal, do you give consideration to, is it something that can be dealt with by legal submission, or is it something you need to call expert evidence on? And that's all I'm going to say at this point in time. Thank you.
Thank you for that. It is actually quite interesting how often foreign influences infiltrate UK adjudication. We tend to think of it as essentially an English jurisdiction, but of course, even now we still procure materials from abroad. And if, for example, a bit of processing plant has been shipped over from France, it's not unusual in your adjudication to find a load of emails in French. Whereas in arbitration there are elaborate procedures for agreeing translation, unless you've had the foresight to include it in your terms and conditions, there'll be no such procedure in adjudication. So thank you for the English perspective. I now want to ask our resident Irishman to step up. James Bridgman has the initials SC, Senior Counsel, and he wasn't required to change them on the passing of the Queen. I used to have some really smart initials, KF, KQC. I've now turned into something that sounds a bit like a fast food outlet. Let me hand you over to James.
Good afternoon. I decided that I'd talk primarily about construction adjudication in Ireland when I was invited to participate in this panel. But just very quickly before I do, Ireland is a plain vanilla uncitral jurisdiction. It is plain vanilla because that's what we asked for when it was first introduced in 1996 for international disputes, arbitration of international disputes. And that was continued into 2010 when it was updated and extended to both domestic and international disputes. So it's a plain vanilla uncitral jurisdiction. And will remain so. We have a Mediation Act. Mediation is regulated in Ireland, and that's for another day. And moving specifically to the world of construction, there's always an unusual aspect about the Irish industry is that there's a preference for conciliation, and there has been for quite some time. And I don't really know why, but I suppose you'd all know Professor Bunny, and he was very involved in FIDIC, and I would have thought he was very influential in the thinking on construction disputes in Ireland, and so with conciliation became the dispute resolution process of choice, really, including for the state, because the state had always had a problem trying to get civil servants to agree to settle something, and so they have a unique rights-based form of conciliation for state contracts, which facilitates the decision maker within the public service because they have a rights-based recommendation. Moving to adjudication, it took 20 years for adjudication to be introduced in Ireland. The 2013 Act was brought into effect in 2016, and what was produced is something very, very recognisable. The mandatory adjudications available, specific to construction contracts, their provision for interim periodic stage payments. Following the request, the responding party is expected to explain why monies are being withheld, and I'll come back to that. The right to suspend work, the strict time limits for 28 days, 42 days, what's agreed by the parties. Adjudicator appointment is by agreement with a mechanism for default appointment, which I'll come back to as well. And then the adjudicator's decision is binding but not final, typically a sole adjudicator. Parties go back to back on costs. So everything I've said there you're familiar with, and what I'd like to emphasise within this is that if you're adjudicating in Ireland, you'll have the same job as if you were adjudicating in England. The difference is the context. And Ireland has a written constitution, and the written constitution will always impact on legal procedural matters. And Article 34 says that justice shall be administered in courts established by law, by judges appointed in the manner provided by this constitution. So justice must be administered by judges, but then Article 37(1) says, nothing in the Constitution shall operate to invalidate the exercise of limited functions and powers of a judicial nature, other than in criminal proceedings. So the categorization of the adjudicator's role has a constitutional context, which is it's the exercise of the administration of justice by somebody who is exercising limited functions of a judicial nature. And that impacts not on the job you're doing, whether you're looking at delay, disruption, all the smash and grab and all the rest. Not on that, but what you are. You're, if you like, in an elevated position in the law. Now, the consequence of this was that at a very early stage, you see, up until 96, we had contractual adjudication. It made its way in. It was very familiar. All Irish practitioners are very familiar with the UK because we work in 2 jurisdictions in the main. And so we were very familiar. And, of course, Peter Coulson's book was the Bible, still is the Bible everywhere. So what happened at a very early stage was, to my surprise anyway, because of this situation, because it's a constitutional concept, because it's legislation, and also because the legislation provided for the appointment of a panel of adjudicators by the minister. Now, that meant with a chair. So there is this person who's the chair of the panel, the minister's panel, and there's 36 of us who are members of that panel. So 36 of us, and I see a number of us here in the audience. So effectively that gave an opening at an early stage, and I was the defendant in the case O'Donovan and Bunny and Bridgman, and Niall Bunny was the chair of the panel, and I was the second defendant. Responded in a judicial review, and that was seen to be a way to go to challenge the appointment at the very beginning. Now, since then, some question mark has been put over whether or not it is the appropriate way to go, whether it is a public law thing or a private law thing, and that remains to be litigated. And the person who put the question mark there was Mr. Justice Gareth Simons, who is now in he controls the High Court list for adjudication. So all work will go to him, and he'll really put a stamp on it in the same way as Peter Coulson put a stamp on it over here. The second thing within the Constitution is the question of confidentiality, because as I said earlier on, the Constitution says that justice shall be administered in public. So if this is an administration of justice, it doesn't. It must be in public. We don't have John Doe cases in the same way as they have in other jurisdictions, not allowed, and family law, limited circumstances, sex cases, limited circumstances on the criminal side. But generally, you can't go in camera. And so that may have an impact, but it hasn't had an actual impact on anything that I'm aware of myself yet, but I just flag it for you. Another thing is that there was an understanding, since a case going back to the days of the arms trial, for those of you who are historians, in Ray Haughey, and there was almost a very, very strong belief that you have a right to an oral hearing in Irish dispute resolution. And that wasn't an absolute right. It never really was, but it was believed that you could always get an oral hearing in anything once you asked for it. But in fact, it is more nuanced than that. And Gareth Simons has pointed that out in a recent judgment, that there isn't an automatic right to an oral hearing. So, as I say, it's a common law jurisdiction, and with the result being Ireland and being where we are geographically and historically and politically and all the rest, and being the second oldest common law jurisdiction in the world, we have always looked to the courts of England, who have a much heavier caseload. A lot of Irish legislation was based, even since independence, on English legislation. The Irish Copyright Act was actually an infringement of copyright in the English Copyright Act, which made life very easy, because the thing was that the issues that came up had been litigated in London. So that's always been great. But Gareth Simons said in a recent case, he said, there's an understandable temptation for practitioners and judges in this jurisdiction to borrow from this extensive learning that in Coulson's book, when interpreting and applying the Construction Act 2013. The case law from England and Wales must, however, be approached with a degree of caution. This is because there are significant differences between the legislative approaches adopted in the two jurisdictions. There are also significant differences in the procedure governing the enforcement of the adjudicator decision. These distinctions are all too easy to miss, in that many of the concepts underlying the UK legislation seem so familiar to us. That's an Aiken construction. Now, I'm saying that, and then he went on in that case to list a number of issues. But I'd really like to emphasize that when you're sitting as an adjudicator, it doesn't really make a very big difference to you, because they tend to be procedural issues that are there. In substantive issues, though, one of the major differences is the scope, because in Ireland, a party to a construction contract has a right to refer for adjudication in accordance with the Act any dispute relating to payment arising under a construction contract. Now, that's narrower than any dispute that you have in English legislation. But everyone has always dealt with that by saying, sure, every dispute has to do with payment. You know, delay and disruption, that has a payment issue because you've refused to pay because of... But the point is that there are potentially declaratory actions that may arguably be outside the scope of adjudication in Ireland. It'll be well flagged if it comes across your desk, and just to be aware of it. I made some other notes here, but I think what's important is that the courts have been very supportive of adjudication and arbitration, they're very, very supportive of both of those. Mark Sanfey, Mr. Justice Mark Sanfey, has the arbitration list, and Mark was a construction lawyer. Mr. Justice Simons has the adjudication list, and he came out of a planning stable, so he's well used to tribunals of one sort or another, and the scope and using tribunals and tribunal procedure. So it's in a safe pair of hands. But I very supportive, but I wouldn't call them deferential. So I don't really have the measure of Mr. Justice Sanfey yet. But in Mr. Justice Simons, I wouldn't certainly not deferential, because in O'Donovan and Bunny and Bridgman, that case, it took 2 years for that to come through. That's a problem, and that's why the eyebrow was raised, because it happened during COVID and it went into judicial review, which meant leave, and I had a stay that was lifted once during the procedure, and took me 2 years before the stay was lifted, and I had 5 days to finish left in the 28 days or the 42 days to finish my decision. So, but I wouldn't call it deferential, because in the course of that case, the judges looked into my decision on whether or not I had jurisdiction. Now, there's no competence, but there was a decision that you'll read, Mr. Justice Moore at the time, and you'll see that he just completely, he didn't consider the reasons I gave for continuing before I was stayed. So I wouldn't call it deferential. And then in another case that I just mentioned, in Acon Construction Services, similarly, the court has said that the issue that was there was whether or not a true value decision should have been made by the adjudicator. The adjudicator applied Grange developments and just gave a smash and grab order, take your order and come back when you've paid it type of decision. He said he enforced that decision. He didn't give smash and grab the imprimatur, or the if you like, the default decision, his imprimatur. He just said that the decision was not did not offend due process, that did not offend fair procedures. He said that was the only thing before him, and he gave the applicant the order. But he did raise a question as to saying that a full consideration of that could only properly be carried out in substantive proceedings initiated in respect of the adjudicator's decision. Now, I don't want to get too technical about this, but it seems to me that some of the statements in that case are begging more different types of applications to be brought, and it hasn't happened, so I'm not going to go into that. If you invite me back and it happens, I'll tell you about it. The adjudication then, I'll just give you 2 minutes. The chair of the panel has gone out. Bernard Gogarty is the chair, and he has to report or give a report to the minister every year. His present report is due any day now, so maybe the first week in November will be a lot for us between the Queen Mary report and Bernard Gogarty's report coming out at the same time. But he went out to the stakeholders, and we on the panel have been asked to give our views on how it's going. And so will there be an adjudication 2.0? I doubt it, to be honest with you, because to try to get parliamentary time for primary legislation, I think construction has had its chance. What is, at the end of the day, really so special about a construction person not being paid rather than some other person not being paid, because everybody needs to be paid at the end of the day, and that's a view that has been expressed by one member of the judiciary in a lecture. So it goes on, and I have to quote from Seamus Heaney because I'm Irish, and we have to quote from Seamus Heaney every time an Irish person gives a speech. And it says, since when, he asked, are the first line and the last line of any poem where the poem begins and ends? So it's a continuing thing. It didn't start with the act. It didn't finish with where we are now. And so an English woman, a Welsh woman, and a Scots woman, right? And they died, and they went up to St. Peter. And St. Peter said, you all voted for Brexit. You can't come in here. I said, but I let you in, provided that you can explain the mystery of the Holy Trinity. And one of them said, well, I'm English, she's Welsh, and she's Scots, and we all have an Irish passport. So the thing is that the Brexit lives on, you know, and in an Irish judgment, whether it be in arbitration or in adjudication, it is the judgment of an EU court under the Brussels regulation. And at the end of the day, again, that doesn't impact on you or I being an adjudicator in any procedure, but the consequences of the order is much more easily enforced if it need be in an international context. But unlike arbitration, you can't go forum shopping in adjudication because the adjudication it's an Irish construction contract, as you know, an English, Scots, Northern Irish construction contract, in the same way as people might go hunting around for an order in arbitration. Thank you.
Thank you, James. Rising admirably to the challenge there. I do think it's interesting when we look at how other jurisdictions have adopted adjudication, where they managed to build on the mistakes of the UK jurisdiction, pick out the good bits and leave the mess behind. And the suggestion that the legislation might be reviewed, of course, reminds us of the changes to the Housing Grants Act, where the general industry response was, just when we worked out what the payment provisions meant, they came along and changed them. So now I'm going to turn to Scotland, if I may, and ask Brandon Malone to give you his perspective. Brandon may be known to you as a leading light in Scottish arbitration. He also managed to deliver ICA, finally, after I lost count of how many times it had to be moved because of the pandemic. He may well tell you about that, but I invite him to take the stage.
Thank you, Kim. I wasn't going to speak about ICA, and sadly I haven't prepared any jokes either. I feel quite left out. I should have thought of something. Never mind. Yes, I am Brandon Malone, and I do arbitration, and I'm also an adjudicator and a FIDIC adjudicator, which I'll talk about a bit. The term UK, which we've heard a lot today, and UK jurisdiction, what have you, there are, of course, a number of jurisdictions in the UK. People say UK, they generally mean England and Wales. I do have to point out that Scotland is part of the UK, at least for now. I'm not making any political points. Scotland is a different, I'm not joking, Scotland is a different legal jurisdiction for many purposes. It is a mixed civil law, common law jurisdiction, as is Mauritius, we heard earlier. Certainly, I got taught Roman law at university. I've pled Roman law in court. But after 300 years of a common parliament, obviously there's a lot of convergence. And where Scots law is the governing law, there are a few differences and divergences in construction, but actually not that many. Scots law and English construction law are essentially the same. We use different words so that English lawyers have to pay us to tell them what they mean and keep us all in our little closed shop. I say that, I'm also a barrister down here, so I'm kidding myself. But the adjudication regimes in particular are just about identical. I'll talk about them a bit, but essentially there's not enough of a difference between Scotland and England in adjudication, not really in construction law, generally to form a full paper, really. So I've decided to take the UK government minister approach and ignore the question and talk about something else completely. Sort of. So what I'm going to do is briefly look at the Scottish position, but then I want to compare adjudication in the UK with FIDIC adjudication. So, the Scottish position. We have the Act, the 1996 Act. I was involved in one of the first adjudications in Scotland in '98 after that came in. The regime, as I say, is almost identical. We have a separate scheme, the Scheme for Construction Contracts Scotland. You can go through and try and spot the differences. It seems to me it's mostly words being rearranged, essentially the same document. There are some cultural differences, perhaps because we come at things from a different cultural background, and we do things differently in court, and we don't have things like, we don't have discovery, for example, in the same way in Scotland. I know this is adjudication, not court, but that doesn't tend to inform attitudes. I've found, because I do adjudicate down here as well as north of the border, I found there's more of a tendency to have hearings in cases of any size in Scotland. But that's not always the case. I had quite a big hospital PFI dispute recently where the parties didn't want to have a hearing, and that was fine. There's differences in enforcement, court action, of course, different court procedure than you would have in England and Wales. There's also a thing called registration of the books in council in session, where you're formally recording a document, but that does require the consent of the other party, and of course that's never given, so that's more of a theoretical difference. And then there are some defences available to an award, like balancing of accounts and insolvency, which I won't get into the technicalities of. So that's essentially the Scottish position, not radically different. And indeed, I very frequently, when I sit as an adjudicator, I will have English solicitors and other solicitors and non-solicitors appearing before me telling me what Scots law is, and that's fine. That's the adjudication regime. But I want to talk a little bit about the dispute board procedure, and obviously we've heard about that already today, but I want to compare it with statutory adjudication. And obviously, under FIDIC, we have dispute avoidance and adjudication boards. As I say, I am a FIDIC certified adjudicator, but equally, I've never been appointed as one, so what I'm saying to you is theoretical, and there will be better qualified people in the room to tell me where I'm getting it wrong. But that's, so under clause 21 of FIDIC 2017, looking at the definition of disputes for that purpose is very broad. A dispute is any situation in which one party makes a claim against another, which might be a claim as defined in the general conditions on the matter to be determined by the engineer or otherwise, and a claim as defined there is a request or assertion by one party to the other for an entitlement or relief under any clause of the general conditions or otherwise in connection with or arising out of the contract or execution of the works. So probably even a broader definition of a dispute than we get in adjudication. And you'll all remember there used to be a lot of disputes about, is there a dispute, and has a dispute crystallised, and what have you. And you see less of those these days, but I think under the FIDIC regime there'd be even less of a chance of trying to argue there isn't one. So the appointment, the DAAB is to be appointed within the time stated within the contract, or by default 28 days after the contractor receives a letter of acceptance. So that's a theory. You get a standing dispute board as soon as the contract gets put in place. But again, of course, as we heard, very often that's amended and it doesn't happen until a problem arises, and perhaps not even then. So the DAB either comprises a sole member or 3 members. So obviously a key difference there, 3 members opposed to a sole adjudicator under statutory adjudication. The 3 members, each party selects one member for the agreement of the others, and the chair is appointed with the agreement of the other party's members. And each party is responsible for paying half of the DAB's remuneration. Now, if there's any failure to appoint, then obviously an appointing entity appoints, and that could be FIDIC or UK Adjudicators or RICS, CIR, whoever. Now, an interesting distinction between statutory adjudication and DAB is the dispute avoidance procedure. So if the parties agree, they may jointly request the DAB to provide assistance and or informally discuss and attempt to resolve any issue or disagreement that may have arisen between them during the performance of the contract. Contrast that with adjudication, where generally speaking, everyone is walking on eggshells around natural justice issues. Everyone's terrified to get any sort of preliminary view from an adjudicator in case it gives grounds to challenge down the line for them having made up their mind or being biased. Another really interesting feature of DAB under FIDIC is that where the DAB becomes aware of such an issue or disagreement, it may invite the parties to make a joint request. Now, I don't have any direct knowledge of this having happened. I was speaking to a FIDIC adjudicator earlier, and they hadn't actually seen that happen in practice. But I think that's very interesting. And to our, certainly the common law mind, the idea of a dispute board going out and inviting parties, well, what about this issue? What do you want to do about it? I think there'd be a lot of concern about that. And again, going back to governing law and culture, there is in some culture, and we see this in arbitration particularly, where there's conciliation built right into the arbitration, and no one has a problem with the tribunal making suggestions, trying to sort things out with parties, then getting on with it and issuing an award if agreement isn't reached. Whereas in common law jurisdictions, there is this natural justice concern about, well, we may have said something to you that we regret, we've tainted the process now, you need to leave and we need to get another tribunal in. So cultural aspects which FIDIC, perhaps with its roots, is less concerned about. But even if there is this advice given, then if the DAB is not then bound in any future dispute by any view or advice given, even where that's set out in writing. So a very interesting feature, I think, of DABs when you look at it with reference to statutory adjudication. So the reference is set out in writing. There is an obligation on both parties promptly to make available to the DAB all information, access to the site, appropriate facilities as the DAB may require, and the parties are obliged to continue with their obligations under the contract whilst the reference is dealt with. The DAB decisions to be completed within 84 days or such other period as the DAB may propose and both parties agree. Now, obviously, that's a much longer period. One might argue a much more sensible period than statutory adjudication in the UK. Certainly my experience of adjudication is that for anything of any size and complexity, parties are always or usually happy to extend that by quite a bit, and quite often these things take 2 or 3 months or even longer. I had one that was 6 months long. And of course, sometimes one party is keen to keep it to the bare minimum, won't grant any extensions, and then questions about whether it's possible to complete that arise. Another interesting distinction with the DAB is that they're entitled to retain their decision pending payment of their fees, something a statutory adjudicator can't do. And if that means that the decision is published later than the agreed 84 days or longer period, then that does not invalidate the decision. So the decision of the DAB is binding on both parties and they're obliged to comply with it, whether or not they object to it. This, of course, is also theoretically true of an adjudicator's decision. If payment is required by the decision, it becomes due immediately without a certification or notice. And the DAB has the discretion to require security to be paid if there is a sum due and there are grounds to believe that the payee will be unable to repay that sum in the event that the decision is reversed in a subsequent arbitration. And of course, this is a big issue we see with statutory adjudication, people fighting tooth and nail not to pay because they're worried that they'll not be able to get their money back, particularly where there's been a smash and grab and everyone knows that that's not the final account that's going to come out in the wash down the line, and there's a risk of insolvency. So that is catered for in the DAB. If parties are unsatisfied with the decision, then they can serve a notice of dissatisfaction. And if there's a failure to give a notice within that 28-day period after the decision, it becomes final and binding on both parties. Now that's, of course, not the default position with statutory adjudication. It is binding, but unless that is built into the contract, like you see with NEC contracts, it does not then become final and can be challenged at whatever point down the line, subject to, of course, time bar considerations. And a further step in the DAB process is that where there is a notice of dissatisfaction with the DAB decision, then both parties are obliged at that stage to come together and try to resolve matters amicably, even at that stage. However, arbitration can be commenced 28 days after the decision, whether or not there's been an attempt to settle. So finally, I guess the distinction is on enforcement. Obviously, in the UK under the Act, the courts have been extremely supportive because they've referred back to the intention of Parliament and the policy of cash being the lifeblood of the industry and what have you. So there is that policy imperative that payment is made and adjudicators' decisions are complied with and upheld wherever possible. But that's not the case around the world when you're dealing with DAB decisions in particular. It doesn't have that statutory regime behind it. Certainly it's got the intention of the parties so far as it's expressed in the contract, but it doesn't have a statute behind it. And in some places it can become very difficult to enforce a DAB decision, particularly where it hasn't become final and binding. So if you object to a DAB decision and there's then an ongoing arbitration, whilst it is in theory binding on the parties, in practice you're going to struggle to get a court to enforce it pending the later arbitration decision. However, since DABs are generally used on longer term projects, if it's a decision that's come up during the course of the contract, then since the decision is going to bind the engineer, then that's really how enforcement of that decision is going to be achieved rather than by the court. So that's really all I wanted to say about that. If anyone wants to hear more about Scots construction law or Scots adjudication, I can certainly answer questions about that too. Otherwise, thank you very much.
Good afternoon, everybody. Welcome to this afternoon's session. I hope you've all had your caffeine and cake fix. This afternoon we are talking about experts and lawyers' views on international arbitration. The aim is to talk through 5 topics of interest to international arbitration practitioners, although some of it will impact upon domestic work too, I'm sure. These topics are going to flow through the sequence of conventional arbitration directions from statements of case through to expert evidence. Each speaker is going to talk to their own topic, and thereafter the panel will discuss their own thoughts and experiences on the issues raised, We'll then move to the next speaker and so on through the process. There will be time for questions at the end. So we're going to start with Nick Brown of Pinson Masons. Nick is a multi-jurisdictional lawyer, commercial arbitrator and adjudicator with 25 years of what is described as dedicated experience in the resolution of disputes on infrastructure and energy projects across Asia Pacific, Middle East, Africa and the UK, Central Europe and Australia, the whole world essentially. He's worked on disputes across the world relating to infrastructure projects and transactions including oil and gas, energy, transportation and mining. He's a regular legal writer in the area of construction law and international commercial arbitration. He's a visiting lecturer at King's College London and enjoys a good working relationship with a number of arbitral institutions, including, of course, the ICC and Singapore International Arbitration Centre. So Nick is going to start us off with the pros and cons of conventional pleadings against memorials in international arbitration. Nick.
Testing, testing. Thank you very much, Alexander. Good afternoon, ladies and gentlemen. It's a real pleasure to be here addressing you. I will speak to a set of notes that I put together. I have to admit that the notes are based on the views of other authors and then my own sort of attempt to digest and assess for myself from three perspectives these points. As Alexander said, it's a question of which is to be preferred in international construction arbitrations between the approach of conventional or common law pleadings or the memorial style pleadings. Now, the perspectives that I think we ought to bear in mind in order of importance are business people, from the point of view of users of arbitral services, what's best. Secondly, arbitrators, the tribunals, what's best. And then thirdly, all the other professionals. Now, from those perspectives, I actually think there's probably a consistent view. The question is it pro-conventional or pro-memorial? Now, of course, if we were in another part of the world, conventional would be memorial, not common law. Forgive me, I was born in the Commonwealth. But let's just start with the conventional approach. In my view, I'll look at the relative advantages only to keep it simple. In my view, there are 6 basic advantages to the memorial approach and more advantages to the conventional common law approach, starting with the conventional common law. I think it's not front-end loaded so much. That is to say, it's more efficient if a case is going to be resolved without a hearing. Now that's because, of course, you start with a phase of the case expression in the formal exposition of what one party's position is in relation to their claim, without evidence, without reference to authority, without much argumentation, indeed there strictly shouldn't be any, just a statement of the facts that give rise to the cause of action. And so that's less expensive and can be produced quicker than a full-blown case statement. So it starts on the bell curve at a lower level earlier than the case of memorials. Secondly, the efficiency of issue identification. Now, all of these, by the way, points, they're all interrelated. They're all consequences of each other or the basis of others. The second point is efficiency of issue identification. So the main issues, primarily the facts, of course, are identified earlier in a conventional pleading approach because they have to be set down and responded to without evidence, without argumentation, but just admitted, denied, or not admitted. So you get to know what's in contest factually sooner. Thirdly, efficiency of evidence production, be that documentary evidence, testimony, be that factual witness or opinion testimony. or other forms of evidence. That evidence is not produced until you know the contest over the facts, be they basic facts or matters of opinion. So again, there's this rather efficient staggered approach to the development of the case, which means that when it comes to the production of evidence, you're not wasting time finding and producing evidence that relates to a fact that isn't in dispute. As an aside, there's a very good article that's just been published about modern witness statement taking, and I don't want to go on a tangent, but I do really commend that article because it's talking about what a modern witness statement ought to address. If you add that modern approach, one would say it's a return to the past. But in any event, if you consider the good wisdom of that article, which I'm happy to give you the details for, I didn't write it, then that would even amplify the benefits that a conventional pleading approach can offer. And then, of course, document production. In some senses, it's part of the last point I made about evidence production, because disclosure is the means by which one gathers evidence to produce. But again, of course, that is going to be limited, or ought to be limited these days, to what is truly material to the outcome of the case. So those, to my mind, are the main benefits of conventional pleadings. Turning then to the memorial approach. First up, reasonably complete picture of the case. So there you're getting to grips with the case sooner, at least from the perspective of the initiating party. The party lays out their stall in complete fashion right at the beginning of the case. Now, how would one consider that advantageous? Because it is laying out one's stall, making a commitment that this is the case that we are stating, proving, and arguing that the governing principles of contract and law support. So it's all out there. Now, one only needs to consider the risks associated of stating one's case in that fulsome fashion to then think, well, then what about the prospects of resolution? Because if one has to make that commitment sooner, then the prospects of understanding the risks of that case succeeding or failing will occur sooner. And so the chance of settlement and the chance of understanding the true issues, at least from that perspective, comes sooner. And that in itself can be efficient to the resolution of a dispute. But of course, the initiating party, the claimant, sets out a lot of information, and some of that information may not be contested by the responding party. So perhaps there's some wastage. Indeed, there is wastage if the claimant can't foresee what will be contested by the respondent. So laying one's stall out has its benefits, but perhaps a risk of wastage too. I've said then it may enhance the prospects of success, certainly when the responding memorial comes and one can see what issues are contested, then it's all out there, isn't it? Now, it can always be amendment, there can always be, you know, the development of one's case, and that's often in practice what occurs. But at least in first instance, on both sides, the entire case is exposed. And the other benefit of that, then, it will filter frivolous claims. If one is making a claim for an ulterior purpose, then that will become swiftly apparent in the claimant's memorial, or ought to. Assessing the evidential strengths and the weaknesses of the case will also become sooner, will be more apparent in a more fulsome statement. The oral hearing will be lessened if most of the case has been expressed in writing. There's less need to have the case articulated in an oral way. The case can, of course, be argued and enhanced orally, but there's less of a need for the oral hearing of evidence. So one can see efficiencies associated with the memorial style approach, and certainly in terms of resolving the disputes sooner, the prospects of that, in theory, that is a major advantage of the memorial approach. I'm going to be very interested in what my fellow panelists have to say from their perspectives as experts, advocates, and arbitrators themselves, because we all have our experiences of the reality of memorials versus common law pleadings. So I'd be interested to hear those comments. But for me, that's all I have to say. Thank you very much.
Thank you very much, Nick. Yes, can I ask our panellists for some thoughts? Gary?
Yeah, Nick. I mean, for my part, I think there's, I don't know if can everyone hear me with that? Is that, yep. I'm not sure whether it's all about the timetabling generally, that from an expert perspective, I've been involved in conventional pleadings where somebody says we're claiming X hundreds of millions. It will be in our expert report, so we're not going to tell you how we build that figure up. And then the directions are that the experts are to produce reports. So I ended up in a situation in arbitration in that case where I had no idea what the case actually was that I was responding to. So I think it perhaps goes a little bit wider than just saying, is it memorial or conventional? Maybe you've got to look a little bit wider.
I think that's a fair point, because I think the conduct of the case in other ways must be aimed at getting to those issues as soon as possible. And it may be that pleadings of either nature will be amorphous as to what the true issues for expert opinion are.
Yeah, no, agreed, Nick. I mean, I think the point for me, I think, is if you can actually understand the case that's being made and the timetable is sufficient for each party to respond, I think with the memorial, you do have the chance of seeing that you know what people are saying from day one. I appreciate it's more front-loaded in terms of effort, but I think the sequential nature of it is perhaps more beneficial.
I think certainly I can see the difficulty with a memorial-based approach, particularly for a quantum expert. It's particularly acute because you don't have all the material or all the issues crystallised at the time that you're doing your initiating report. And so, particularly for a respondent, you're saying, well, what am I answering here?
Yeah, absolutely.
Yeah. Kim, any thoughts?
Thank you. So I've got 2 points to make. Let's not forget what this exchange of statements of case is actually for. It isn't to get everyone bogged down in a load of work for a period of time. The purpose is to define the issues. And tedious though pleadings are, they are very good at defining the issues. With memorials, it is much easier to obfuscate the issues, if that's the intention, or much harder to identify the issues, which ought to be the intention. And the other point is that from the tribunal's point of view, increasingly the parties ask for a really extended period in which to produce these memorials. And it's not unusual for them to ask for 6 months for the statement of case and 6 months for the statement of defence. And for the tribunal's point of view, that means by the time the pleading process is closed, they really have forgotten what the case was all about from the time that they were appointed, which probably wasn't the intention that the parties had.
Yeah, so overall, a longer timetable. And then there's the business, once the memorials have been exchanged, of gearing up for the hearing. Oh, what did I write, 9 months ago, and so on, as an expert, is difficult. Does anyone have any thoughts on Nick's suggestion that memorials might reduce the hearing length? I must say that's not my experience. There's still as much stuff to cross-examine on and investigate as there would be with conventional expert reports coming at the end of the sequence.
The hearing will be as long as the hearing will be. And I don't think either process makes it necessarily longer or shorter. The secret to making your hearing efficient is to be clear about what it is that you're arguing about and making sure that your evidence is focused on those points. Now, if you're able to pull out from the morass of memorial material those issues and that evidence, then your hearing will be efficient. If you then have to revisit them all because everyone has, for want of a better term, lost the plot, then your hearing will be messy and chaotic as a result.
There is, of course, an analogy, just to bring the theme of this conference right back to adjudications, of course, because in a sense an adjudication submission is a memorial. And that seems to work.
You tend not to have a hearing in the main.
That's true. That's true.
Ah, well, that supports my point.
All right. Well, thank you very much, Nick, for that presentation. Next up is Dan Miles of Aquila Forensics Limited. Dan is a director and co-founder of the company. He's a chartered QS and expert witness with over 15 years' experience working on high-value complex disputes and has given evidence multiple times on many international arbitrations. He's a specialist in the provision of quantum advice and opinion in all forms of dispute resolution, including arbitration, adjudication, and mediation. And he's had many appointments and acts as advisor in disputes on various forms of contract, including, of course, FIDIC and JCT. Dan's topic is the practicalities of sampling in respect of evidence and document production in international arbitration. Dan.
Thank you very much. The one piece of good news of everybody listening to this next section is I've been told very firmly not to exceed 8 minutes. So I promise very hard to try and retain myself within that, because frankly, much more than 8 minutes on sampling is probably quite tedious for everybody. Taking sampling, though, I'll set my stall out at the start and saying I think it's a particularly important vehicle for minimizing costs and maximizing efficiency within arbitration. But I'd like to say at the start there are two forms of sampling. Number one, we have sampling in terms of validation of opinion, and the second form is validation of factual evidence. Discussing opinion, you'll see this more often, I would suggest, with technical experts. An example could be there's a defect within a highway. You may choose to take samples, core samples, from that highway at defined locations. So the opinion might be there's a defect, and the sampling process is trying to validate that opinion. In a quantum realm, you tend to find it's more linked to validation of the factual evidence upon which you're relying. An example, just to try and bring this back, might be verification of cost to be included in a prolongation claim. Whether you want to take a cost as an indirect cost and a time-related cost into your prolongation claim, or choose to exclude it, will often have to be based upon the underlying evidence and the invoices supporting the cost claimed within a cost code system. The problem we have, though, is that even a small or moderate-sized project can easily have cost codes and cost data running to 10,000 or 100,000 rows of data. And in truth, it's not always practical to try and look at every single invoice for every underlying cost claimed within that prolongation claim. So to try and actually validate the cost being claimed, we will often want to apply a sampling process to validate from the actual underlying evidence the cost being claimed. To do that, though, there's two elements that could be considered. Number one is an entirely unbiased random selection of costs and invoices to review. But whilst everyone seems to favour this approach, it negates the fact you've engaged an expert, hopefully, with some expert opinion and some experience, who should be able to guide the sampling process towards the key areas that need to be reviewed. For example, you may have a concern over plant being costed and claimed on a project. Therefore, I suggest that actually what's needed is a mixture of both a biased and unbiased sampling approach. Unbiased, to make sure you don't miss anything, and a biased approach using your experience to target the areas that you feel most require the sampling to be done. I think I'm on 5 minutes. I've got 3 minutes left, so okay. So using that experience, we then hopefully can undertake a process to which we can validate, for example, cost codes and validate the categories of cost taken into our claims. And this brings us to the question of accuracy versus precision, and sometimes the veneer of precision. Where you have 100,000 rows of data, If we've gone through and looked at every single one, we may be claiming to be very precise in our work, but actually there's a veneer there, because it's very unlikely that somebody, and I am very culpable of this, when I was starting out in my career, I was given a 100,000 row spreadsheet and told to allocate, based on the criteria, all of the costs into a series of categories. It's fair to say, rather embarrassingly in the hearing, I have made some mistakes, largely because trying to go through that many rows of data, at some point you're going to misallocate and miscode a piece of evidence. However, on the same job, having looked at the cost codes, we established that the cost code allocation of cost was very accurate. And what we should have done is turn around and establish that out of 50 cost codes, 45 were accurate and correct, 5 were not, and 5 needed to be done on a line-by-line basis, and not all of them. Therefore, actually, the more accurate method would have been the sampling method, and the more precise method was simply the veneer, and not actually better for the overall assessment being undertaken. Which then leads us to consider what happens in document production within arbitration. So often, at the point of document production, they're using a red fern type approach, there's no opportunity to actually take a sample-based approach. Instead, we have costs being claimed, and we need to validate and verify those costs. So we ask for everything. Again, not a necessarily proportionate use of people's time, and so often you don't get everything. When you do get everything, you then realize you don't actually want everything, because you've now been given a 10,000 PDF document. You can't search anything, it's all been scanned in, and becomes an absolute nightmare. Therefore, within our document production, there could be benefit to actually experts agreeing what they want before we get to the red fern, agreeing what data we need, and how we intend to use that data to undertake our analysis. This then goes to the next problem we have with red fern schedules. We have to declare the category of documents that we want. The problem is, we often don't know what we want until we get it. What we know is what we want to do with it. We want to verify that the labour being claimed is correct. We want to verify how many people were present on site. We know what analysis we want to do, but we may not know what systems our contractor runs. Do they run a timesheet system? Do we have a biometric log at a gate? How are we recording who is present on site? Therefore, what happens is you ask for everything, because you don't know what format the record is going to be in, so we include 5 pages of document request, when in truth, 1 line will be fine. I want to validate how many people were on site, on which days, and what job they were doing. Give me something that proves this. Instead, we ask for pages and pages of documents that generally get objected to, and when they do come, they're not in a format that we want. They're in a format which is not electronic, a format that we can't replicate and we can't analyse. So again, I would argue, where we can meet with our fellow experts and we can work collaboratively for the benefit of the tribunal, we have the ability to reduce the scale of our document requests and increase the efficiency with which we do our analysis. I think that
Perfect.
Only a little bit over.
Perfect. Thank you very much, Dan. So, panel, what do we think on Dan's points about sampling and document production? Certainly in international arbitration, my experience is almost invariably the use of red fern schedules. And the point that Dan makes is that they don't really work for experts, and is there a way around that? Has anyone seen a different route being put forward?
I guess it would only be, as Dan says, to get the experts together beforehand to see if they can actually identify what they can do. In fact, Dan and I worked on a case on opposing sides probably a year ago, had reasonable success in identifying samples. I guess for me, one of the points that came out about sampling, and it's probably more for Kim, Nicholas and Alexander, is that a colleague of mine was involved in an arbitration recently where he engaged in the sampling exercise looking at prolongation costs, sampled 80% of the documents only to find that the award from the tribunal was to say, we're not going to award anything for that portion that you didn't sample. Now that was a complete surprise to me. I don't know what thoughts might be on that.
Yeah, that would be a surprise. I think it depends on how the sampling is expressed. I think what the legal team wouldn't want to be making clear through the evidence of the expert is that by sampling whatever it is, the 80% or whatever, that the expert is expressing a positive view that he's satisfied or she's satisfied that that's a representative of the bit not sampled and therefore constitutes evidence, albeit of a lesser category, of the 100%. I think if it's only expressed as I've seen 80% full stop, then you fall foul of the problem. You haven't proved the 20%.
I think also just picking up that one, there's a definite distinction, particularly within quantum, between sampling of the underlying factual evidence and sampling of an opinion-based element. And if your sample is now, we have 2,000 variations and I've sampled the accuracy of 150, then that's going to be a far more risky scenario, because potentially each variation there's a question of entitlement, there's a question of quantification, there's a whole series of underlying questions below that for which sampling may not be appropriate. From a quantum perspective, I think sampling is often more successful where we're discussing verification of the factual evidence rather than the opinion-based element.
No, I'd agree, Dan. I mean, I think in terms of the variation point, you then get into the interpolation and how you interpret those results. I mean, I've been involved in a case in that recently where we had to look at a number of disputed variations and then look to interpolate our findings. And I think that, again, leads to its own difficulties. Don't know what lawyers have to say about that.
You've been thrown the bus there, haven't you?
I'm wearing three hats today. I would say that there's a distinction between the legitimacy of sampling and the problem of getting to the data, and I think you're making those 2 points. As to the latter point, I would draw attention to the 2019 report of the ICC Commission on ADR, the report on construction arbitrations under the auspices of the ICC rules. You'll be aware the ICC is headquartered in Paris, and its rules are very much a hybrid of two traditions. And if you're looking at the point of view of data, getting access to data from a point of view that you're an inquiring tribunal, which is not necessarily the common law perspective, but you're going to get to the facts, and you're going to have these experts help you get to those facts, then it's an entirely different scenario. What that report recommends as one solution to this problem of getting to the data is not only get the experts together early, but also have one of the members of the three-member tribunal sit with them and manage the acquisition of the data that they both accept they need, and to then agree what is the database.
And with your tribunal hat on, as the second of your three hats, what appetite do you think there is at an early stage when the tribunal don't really know much about the case? Would there be to intervene or supervise that process?
In practice, I'm sitting as a co-arbitrator in an ICC case at the moment. Chairman is a Swiss lawyer. I'm hoping he doesn't appoint me to go and sit in that meeting. And I think in practice it's very rare. And I think that's the magic of that report, because it's identifying what well may be a solution that isn't yet in practice.
Just jumping on that point, and I apologise for going out of the sequence for our topics today, but the flip side to that, I would suggest, also has great benefit. I've only seen one arbitrator do this, but I've seen them do it on 2 occasions, which is recognising that sometimes the tribunal can benefit from the skill sets of the experts. And particularly when an arbitrator asked us to sign documentation saying that we would support, in the case quantum, so we would support the arbitrator in the final calculations and check their maths without disclosing any information to the parties prior to the award being published. And there's benefit, I would suggest, going both ways there.
Just harking back to document production, my experience of it is that Redfern schedules and the process of production does very much assume traditional paper background, when of course, you know, that's not how businesses operate now. Everything is databases and search engines and so on. I'm not sure that the Redfern process is really cut out for that. I mean, you need to be able to give people access to databases, to search materials and so on. How easy has anyone found that in practice? And you deal with delay solely, I think. I mean, what is the sort of documentation you'd be trying to get access to?
The sort of thing that comes to mind, and looking at events recently, is the consequences of COVID and its impact on the efficiency on which site works are carried out. Sampling has sort of come up as a solution whereby what happens over the course of time is what, say, the contractor would say is that there are certain measures that I now have to instigate which affects every member of staff and every operative on the site. So on a day-to-day basis, whereas you could, if you went back to your tender, you would be expecting to work 8 hours a day typically, that starts to be eaten into, and for various measures it might come down, say, let's say 6 hours. But it can vary from employee to employee and different trade and trade. So I did an exercise recently whereby sampling over fairly narrow calendar periods rather than, say, a overall period of 2 months, and used that as a basis by extrapolation to try and come up with a realistic figure or practical figure for how much time would be lost and associated with this. Now, these are still current disputes, and so the jury's still out, but I think that's an approach where it might be beneficial, rather than having to invest in what could be very intensive months and months of analysis of probably several analysts being involved, and then that, you know, it could be the scenario that all of that, depending on how the experts can agree on this, ultimately that might have to be repeated by the other side if they choose to dispute all the evidence presented.
This idea of having an interventionist tribunal at an early stage working with the experts either to choose representative samples or access to documents all sounds lovely and I suspect is in the interests of the process. But I think the practicalities are huge for it. With the tribunal hat on, there'd be real nervousness at an early stage with shutting out a limb of the case or misfiring on the selection and then finding out when you know a little bit more about the case a year down the track that you've sent everyone down the wrong rabbit hole. And so the default is, from a tribunal's perspective, leave it to the parties to try and work out the best way. We'll not tell you, but we'll tell you when you got it wrong.
I would suggest, coming back to Gary's point earlier on, is that actually, rather than the tribunal directing that sampling process, where the experts are behaving sensibly and recognising their duties to the tribunal, it's for the experts to actually meet and agree appropriate sampling strategies and using their combined expertise to actually get to the data and to get sensible outputs that then everyone can be happy to rely upon and use later on.
And that is a particular area, isn't it, where the duties of an expert to the tribunal might clash with the duties to the client. Because you can certainly see the client saying, well, you know, I'm not letting them near that, or you know, I'd rather they chose a different limb of the project to be looking at, or whatever it may be, whereas the experts may take a different view.
I think the debate does highlight the need for early involvement of the experts on both topics, because sampling works a treat if everyone agrees how it's going to be done and what it means. And by everyone, that includes the tribunal. And if they don't have that agreement, then the argument becomes about the sampling process rather than the merits. And I think that's what happened with that potholing case that Stephen Davis decided. And with the documents, equally, I think lawyers tend to be drawn to narrative form of documents. So that's correspondence, site-minute meetings, and written memos and records that tell a story, whereas the experts tend to be drawn to records, which lawyers tend not to want to look at because, you know, for them it's relatively meaningless. So you have this kind of clash of basic data, and it's not unusual for the lawyers to plead a case along a certain line and then the experts to dig out those records from behind the filing cabinet and discover that it's basically not quite how people saw it, either on liability or on quantum, and then there's the hoo-ha about whether you amend and so on. Whereas if the experts were involved at the outset, dug out those records, advised and informed the clients, and then that information went into the pleadings, then the whole procedure would get off on the right foot from the start.
Yeah, understood. All right, well, I think we can move from the topic of disclosure and sampling, thank you very much, Dan, to Kim's next topic. So Kim Franklin, KC of Crown Office Chambers, is, of course, a recognised specialist in construction engineering and the infrastructure sectors. Kim took Silk in 2016 and now acts predominantly as tribunal, resolving disputes from complex projects in international arbitration, dispute boards, and as a UK construction adjudicator. She's been appointed by the ICC, ADCCAC, and DIAC, there's lots of C's in there, DIAC arbitrations in the UK, UAE, and GCC, and acts as sole arbitrator, party-appointed arbitrator, and tribunal chair. Kim has a flair, as described, for technically complex, document-heavy disputes with a reputation for clarity, strong case management, and sound strategic judgment. And her adjudicated decisions are always met with judicial favour. See the Essex waste case, which he describes as about as good as it gets. So Kim's going to talk to us about statements of witnesses of fact, particularly in international arbitration.
Well, thank you, Alexander, for that stellar introduction. I wonder who wrote it. So I've got a 40-minute talk on witness statements, which I've got to cut down to 8 minutes. If you see Alexander run and exercise the guillotine, you'll know why. Can I just talk about witness statements? So I want to look at this really from the tribunal's point of view. Tribunal were mentioned as one of the important people when it comes to how do you go about preparing your evidence. And let's look at this in a bit of a historical context, if we may. So back in the 1980s, which was when I qualified, the Technology and Construction Court introduced written witness statements to stand as evidence in chief. Before then, they didn't have that. Evidence in chief was given the long way round. Now, these were considered unpopular at the time by lawyers because they required too much work. Times have changed. Now witness statements are predominantly drafted by lawyers, and they do it beautifully. But the results tend to be that they're a bit on the long side. They don't necessarily reflect the witness's understanding or the language that they use. They are written in perfect English, which very often the witness doesn't speak. And there's a statement of truth at the end, which is sometimes signed on their behalf. The witnesses also dive in and argue the case a bit, taking side swipes at the opposition. There was a case, Riva Properties, against Foster and Partners, where the witness considered the term world class being applied to the architects as a bit of a hackneyed phrase, and the judge didn't like that. The witness statements tend to include evidential references which predate or post-date their own involvement, and reference to letters that they didn't write and meetings that they didn't go to. They often include the witnesses' opinions. And another cardinal sin is that they do not provide relevant evidence which the witness is actually best placed to give. And that's been coined as the dog that doesn't bark. So this relevant omission from the evidence is often more revealing than the irrelevant inclusions. And in short form dispute resolution like adjudication, it does entitle the adjudicator to make adverse findings. Well, you haven't dealt with this point because if you did, you'd have to admit that you got it all wrong. Now, these points were best illustrated when I was sitting as an arbitrator on my own in Abu Dhabi, and a commercial manager witness came along to give evidence, and the opening line in his statement was, "In my opinion, these proceedings are a complete waste of time." Now, it's never a good idea to tell the arbitrator that they're wasting their time, but particularly not when you are the claimant. And in this case, you were claiming for wasted management time. So, against that background, let's think about what makes a good witness statement. So a bit of context again. As junior counsel, I used to be asked to advise on evidence. And what did that mean? Well, it was done after close of pleadings. And my job was to work out what the issues were. I'd then identify the key factual events, who attended or witnessed them, and I'd list out the potential witnesses and the events they needed to cover. And then my instructing solicitors would go out and try and track down these witnesses. They'd prepare a statement and they'd report back to me on how they thought these witnesses would fare in the witness box. So times changed again. Later, I was just sent the draft witness statements and asked if the solicitors had missed anything. And sometimes they had, and usually it was on quantum. But then that stopped, and witness statements became increasingly detached from the issues, from the documents, and from the witnesses themselves. So a common trend, and this is particularly in arbitration, is at the end of a project where something's gone awry, a commercial director is brought in to try and mop up. So this director will read the file, they'll talk to the project managers, they'll dig about a bit, they meet with the other side, and if they can't sort it out, they instruct lawyers and they explain what's gone wrong and why. So the lawyers will take a detailed statement reflecting their instructions, and they'll proceed with that commercial director as their main point of client contact. And when the dispute goes to a tribunal, they submit that director's statement. If the director has strong views, and in my experience they usually do, they go into their evidence. Now at some point that director will be interrogated, and then it will become clear that the director has no first-hand knowledge of what happened at the time whatsoever. The tribunal would be entitled to draw a line through the witness statement. It would tell them nothing that they couldn't work out for themselves from the documents. It would be a colossal waste of time, energy, and resources. And also, it was a missed opportunity to provide the tribunal with the evidence that they wanted. So what's a good witness statement? Well, it's short. Let me say that again. It's short. It deals with the issues, and it only deals with the issues. It gives evidence of fact only. Any sentence that starts, in my opinion, is not evidence of fact and gets crossed out. It contains first-hand testimony only. I am informed that is not first-hand testimony. It's drafted by the witness in their language. And if their native language isn't English, they should explain how this statement came to be prepared. And if they don't speak Latin, they don't use adjectival clauses or the subjunctive, those should not appear in their witness statement. And if it's prepared with reference to the documents, it should be documents that they wrote, meetings they attended, and discussions that they held. So why go to all this trouble, you might ask, over a witness statement? Well, this actually is a good question, because construction disputes should be well documented. There's lots of photographs, there are records, and there's payment details. And if you haven't got them, you've got to ask yourself, why not? As I said earlier, I bet you they're behind that filing cabinet. Go and have a look. Delay experts tend to use those records rather than the correspondence and the witness statements. So very often, you know, the key expert evidence can be put together from records that don't require expert and witness narrative at all. You only need it to plug the gaps or to explain the photographs. Now, for nearly a decade, the courts have been worried about this problem. Back in 2013, there was a case, Weatherspoon and Harris, where they set out what they thought should be in a witness statement. And it's not until only recently, last year, that we had practice direction with the catchy phrase 57AC, which has an appendix and a statement of best practice, which applies to trial witness statements. Now, usually I put some nice slides up now so that you can see them. So I haven't got them, and I'm not going to read it out. But there are two important things in that direction: that witnesses verify their statement with a statement of truth, and that the legal representative certifies compliance with the practice direction. Paragraph 52 empowers the court to impose sanctions, including striking out offending parts of the statement. Sanctions sort of give a shiver down the legal spine and make them think that perhaps things are going to get interesting. And they just have recently in a case called the McKinney plant, where objections were taken to the witness statements, which were rejected as being nitpicking. They went to see the judge about this, who took a dim view of the allegation of nitpicking and thought it was entirely justifiable, and awarded indemnity costs against those who had made the improper complaint. So these requirements now highlight the fundamental question: do you need witness statements? It requires thought and analysis. You have to identify the relevant witnesses and their evidence and the documents, and then you have to tie it into the issues, which comes back to my earlier point. You can't produce evidence until you know what you're arguing about. Statements are going to take longer to prepare. They might be shorter. And you won't get a very good reception in court if you don't comply with these requirements. So I'll just finish on the point: what does all this mean for arbitration? Because the rules are slightly different there. Well, unfortunately, I do think it might mean an increase of the use of the memorial, because you need to get the documents in. You need, if you haven't got a witness who gives a kind of generic explanation of the narrative, project narrative from beginning to end, it's got to be given by the documents, and you want those in sooner rather than later. And tribunals can and will, and in my experience are increasingly keen to make CPR-style orders, particularly asking for those declarations. Remember, the witness gives a statement of truth and the solicitor has to certify compliance. So I suggest you draft one that suits your own requirements. That's you, the practitioner, you, the tribunal. Which will mean that the witness has to certify that they are giving evidence from their personal knowledge only. And let's see how that goes, shall we? Thank you.
Well, thank you, Kim. I think the difficulty, of course, is knowing or having sufficient confidence that the tribunal will work its way through the narrative story on the documents without the director's witness statement. True it is that it has no forensic value when he goes in the box, but as a collator of the document trail, it's very useful. And without that, and unless the tribunal have a narrative story that they can work through a chain of documents, there is a difficulty, isn't there?
Do you want to deal with
that? I'll just posit the suggestion that the pleading could contain that, so that it wouldn't be faux testimony. Well, that probably doesn't matter because it's seen for what it is. It's a story, a narration that assists.
Yeah. Gary, what's your experience of witness statements?
Speaking, I'll now do the two-hatted thing, Nicholas, and say as an adjudicator, I don't find much benefit from factual witness statements. I find that most of them are self-serving, of little use, and probably set out exactly what Kim has said, the commercial director's view. Here's the case, this is why we think we should win. I think on a more positive note, where I've found witness evidence quite useful is when, as an expert, I've actually worked with counsel who've said to me, look, this is the case we're either making or defending. What evidence do I need factually that you can't get from the documents, and help me with that? And that's where I've found that particularly successful, that I've seen parties then focus, when they've worked with the experts, I'm sure maybe Russell will have a similar view on the delay side, that if you actually know what evidence it is you need to make the case, and it goes back to what Kim was saying about identifying the issues and understanding what it is you need to actually prove to win the case.
Russell, any thoughts?
On the positive side, I think often I do find on delay-related disputes, one of the major hurdles I have is a shortage of evidential material on which to base my analysis. And there are those instances where I think the phrase plug the gap is inevitably you have to refer to witness evidence to assist on that. And it's not unusual that you find your opposing expert is doing exactly the same. And in those circumstances, it becomes a little bit of a, not so much a battle of the, if you like, the credibility of the expert witnesses, but the witnesses of fact they're relying on. So that's one instance. Another one, and irrespective of which party is doing it, is sometimes it can be very, very beneficial, I think, from a tribunal for somebody who's lived with the project to actually just tell the story of what had happened from day one to the final completion, and just to put that down in writing, because sometimes I think as people who are not involved firsthand as experts, we have to go through a learning curve to understand what actually happened and don't have the benefit of first-hand experience. So to a degree, we're less well qualified from somebody who's on the ground. Having said that, I think I would agree with Gary, is a lot of the time witness evidence can be very self-serving. I recall one particular dispute where there wasn't a lack of, call it factual evidence in order to establish what delays had occurred on the job, because the contractor concerned had provided lots of progress information on a regular basis. The problem for him as the claimant was that didn't actually support the contention he wanted to make, which was to assign responsibility for a lot of the delays on the job to somebody else. So in that instance, what they did is to use the project managers to provide witness evidence, which was along the lines of saying, well, although from a planning this was a power plant of a type, although we expect that from a planning perspective that we will need 100% of optimization in terms of power availability to start commissioning, he took a view that in his witness statement was well, we only needed 70%. So those activities which were affected by that, you can discount. We don't need to worry about those anymore. They're not considered critical. So he was running contrary to what was he and his team had actually reported at the time. I challenged this, and as a consequence of that, what I found was when my opposing expert, who'd relied on his opinion, came round to his second report, he abandoned this particular testimony. But lo and behold, the claimant pulled up another witness who would give, if you like, a similar view, but on a different basis. So no longer asserting that we needed 70% of power available, we just needed 90%. And you go through the mill again of having to try and discredit that witness once more. Suffice to say, that job settled shortly after. But I think in those circumstances, you do become cynical, and you can see often witness evidence is not being used in a very creditable way, I would suggest.
Well, we all like a rogue witness. Right, we're going to move into the expert phase of the arbitration process now. And Russell Bates of HKA is going to talk to us about the instruction of experts. Russell has worked in construction and engineering for over 30 years, initially in site planning before moving into consultancy work, particularly in relation to project delay. Over the last decade, he's been appointed regularly to act as expert in international arbitrations, has been cross-examined on various occasions in relation to projects, oil and gas, power and utilities, transport infrastructure, process, manufacture, and buildings. Russell, as I say, is going to talk to us about instructions of experts. Thank you.
Thank you very much. The particular thought I had in mind to consider is whether or not there are instances is when a delay expert is instructed, whether or not those instructions become a device for actually, shall we say, limiting the remit or extent of the analysis to be being done. Now, perhaps as a starting point to distinguish that between instances where the instruction given itself inhibits the level of investigation to be carried out, where, and I've had a personal experience of this, where there are cost issues at heart, whereby either the client is unable to fully fund the costs of the arbitration, or is unwilling for one reason or another. As the respondent, is something of an unwilling participant. And so this was a big issue in terms of one particular dispute I was involved with. So instead of being permitted to do a fully independent report where I looked at all the facts, came and come to an overall view as to what did I consider to be the critical delays on the job, I was restricted to doing just what I call a negative type analysis, whereby all I was permitted to do was critique my opposing expert's report. So you can have instances of that. Another category that comes to mind is where the tribunal itself may, for one reason or another, decide to restrict the ambit of the analysis. And that's happened on a couple of occasions. Albeit, I have had a couple of instances where, notwithstanding what the tribunal has directed, my opposing expert has decided to go off on a frolic of his own, if you like, and actually introduce a lot of new information and a lot of analysis that the tribunal clearly directed him not to do. In one particular instance, it actually worked, because the tribunal didn't throw out the information. Is that what they decided to do is to say, well, I think what we should do is consider that as a possible alternative option, and we will take a view later on when we come to give a look at our award. So there's those sorts of scenarios, but I distinguish those between instances where it's not where somebody's tried to limit what I say or do, but certainly in instances where the opposing expert, when I look at the instruction they've been given, and when I say instructions, is very much, when you read an expert report, it'll be very structured, and somewhere at the top of the report, possibly just before the executive summary, there'll be a terse statement saying, this is what I've been told to carry out. However, it's not unusual, but if you sort of work through the body of the report, you actually find that, well, the expert is actually being instructed not to do certain things. So in one particular instance, what I found was that and it was kind of squirreled away, is two issues. One, first of all, is in terms of assessing delay by reference to the contractual provisions, the job in question was a little bit complicated because it involved an offshore contract and an onshore contract. What became clear is that he'd been instructed solely to analyse the project in relation to the onshore contract and ignore the offshore. That was important because there were certain conflicts, if you like, in terms of milestone completions between these two documents. So from my perspective, you always needed to take into account both. Secondly, it was very clear that in his remit was to define and only look at events within a very narrow period of time. Whereas I think what I ultimately found is that there was a lot of pertinent issues in terms of what happened before and what happened after. But that's something that only became clear after disclosure. So you have those instances such as this where it looks very much as if, in terms of what the instruction is trying to do, is sort of narrow very much the area which they're suggesting is the tribunal should be looking at. Another instance which arose not from a claimant, but where the respondent put in a counterclaim, and as part of that counterclaim they added the evidence of delay expert, albeit that, again, that evidence was very narrowly drawn in terms of what he was instructed to do was to look at a very limited number of documents and form a view as to what was therefore causing a critical delay to the project. It was a hydroelectric power scheme, so although you're building this huge dam and lots of other structures, the only information he was given to analyse was the construction of the turbine house and the fit out of the turbine house. So inevitably he came to the conclusion that delays to the turbine house were causing critical delay. The only problem with this is some of the documents that he'd given, which was a contentious point at the time, the other party was a very, very clear view that they'd been doctored. So not only was, if you like, the remit very limited, but there's an element of fraud to it, you could say. So, pocket there.
Thank you very much, Russell. Any thoughts on instructions of experts? And particularly, I'd be interested if anyone's got any experiences of different approaches being taken from experts in other jurisdictions, and whether the problems they encounter are similar to ours. Dan?
I think the one we've seen quite a lot when it comes to jurisdictional differences is I've seen opposing experts being instructed not to engage in joint statements and in valuing the figures as figures and the alternative case. So you'll have an expert who will only engage in their own legal pleaded case and have been instructed by the instructing solicitors to then not engage in valuing figures as figures, which I would suggest backfires, because if, as somebody always has to, you lose your legal case, you've then only got one set of numbers or one set of analysis to then consider. Apart from a list of criticisms, there's no positive analysis being presented by the other expert, which I would suggest doesn't leave you in a particularly great place unless you're entirely successful in all the legal arguments.
Yeah, I'd agree with that, Dan, and I think just thinking about the whole I'm instructed, I just don't think tribunals buy that particularly. I think that they look at that and say, well, that's fine, you've written that down. What tends to happen is you'll get to the hearing And somebody like Kim or Alexander is going to say to you, well, that's all very well, Mr. Kit, you say you're instructed. What do you actually think? And then you're in that position where none of the parties give this any thought, I don't think. They think it's very easy, it's a let-out. We'll tell you you're instructed to say this, and therefore you don't have to give your true opinion. And I think, that's my personal take on it.
That's where the witness statement jumps in and says, this happened.
Yes, fill the gap. Now I'm wearing my construction litigation partner of law firm hat, and I just want to reflect a bit on the difficulties that one can find oneself in when drafting those instructions. Consider this. The client has a limited budget for this investment. Say the client's a claimant. The project has a budget, of course. That's it. The investigation is going to be costly. Let's consider its investigation into delay, just alone. Now, if it's an issue of whether the contract is interested in a prospective delay analysis or a retrospective delay analysis, the inquiry is very different depending on which side of that fence one has to fall, which side of that fence the tribunal ultimately will be persuaded is the right side of the fence. At that very point in time, the client can't afford both inquiries, and there isn't time perhaps for both. So you've got to take a position. You've got to come to a conclusion on the proper interpretation of those contractual provisions and the facts and the realities and all of the other considerations. We know what they are, but you've got to apply them and come to a view on what the instructions, what scope of inquiry you want the expert to undertake. But then there's that very visceral concern about what if we're wrong? What if the tribunal, Alexander, Kim says, well, what do you think if you accept that the methodology ought to be retrospective and you've looked at it prospectively only? So it's a very uncomfortable position where the professional has to take a view. That isn't always the case, and often it's the way in which you scope the extent of the investigation from both perspectives. But then you come into the other, and I think quite serious, concerns about have you limited the evidence to which the expert has been allowed access, because I think that's more of a concern for an expert than an expert that says, I was instructed that the proper approach that this contract dictates for determining this entitlement was this, and I investigated primarily accordingly.
I think certainly when you're dealing with quantum, there's a perennial difficulty with the instructions to the expert about how you value a particular claim, where the approach might be either, well, if I can't see an invoice or a sample of invoices, I have to put nil in the column, as opposed to an approach which says, well, I haven't seen any invoices, I haven't seen any supporting records, but looking at the story and the narrative, my hunch, doing the best I can to help the tribunal, is X, whatever that X is. It may not be terribly easy to cross-examine on, it may not be anything more than a gut feel, but it gives a steer that is some way between zero, based on audited records, and the maximum claim that's been concocted by the claimant's expert. And knowing where to go with the instructions to the response expert is quite a challenge, I think, on that.
I would suggest that that's the kind of prime example where you get to that figures-of-figures approach and being allowed to value the alternative, which is you're instructed that the correct interpretation of the contract is, without this evidence, it should be nil, your primary assessment will be nil. In a reply report, or where we're on pleadings memorials, there will be a legal pleading back the other way, saying that actually it should be based on these principles for whatever legal reason. Your opposing expert will have valued it at a different number, and then in your reply report, you still maintain your reasons based on your instructions for why your primary is nil, but your alternative assessment, figures as figures, on the alternative legal interpretation will be a different sum for the reasons you set out in your report. Yeah. The danger comes where you don't engage in valuing figures as figures.
Sure. All right, well, we're going to move to the very last step or the last talk. Whether it's the last step is perhaps the question that Gary's going to talk about. Gary Kitt is the Senior Managing Director at JS Held. He's a highly experienced QS, chartered builder, chartered arbitrator with almost 40 years. Did you want to admit to that? 40 years experience in building and engineering projects worldwide. He's been regularly instructed as an expert witness on quantum and international arbitrations on major disputes across all sectors, including oil and gas, aviation, power and process plant, shipbuilding, major highway and infrastructure schemes, luxury hotels and retail malls. Can't think in which jurisdiction that took place. Gary is going to talk about experts' joint statement and, apropos of the comment I just made, the timing of the joint statement. Should it be before expert reports, which we've just been talking about, or after, which is where we've positioned Gary this afternoon, and the content and extent of lawyer involvement in joint statements. Gary.
Thank you, Alexander. So, starting off, I should say it's a huge topic, and like you, Kim, I think 8 minutes, I'll do my best. I'm going to start with timetabling, and in my experience, I don't believe this is given much consideration by either the parties or tribunals. I say this because I've been involved in a number of arbitrations where the joint statement is directed either prior to service and exchange of reports, after service of the first round reports, and after service of reply reports, or a combination of all three. So what actually drives the timetabling? And from what I can establish, there's little rhyme or reason to it. I've asked a number of lawyers, I've spoken to various solicitors who've said to me, it's in the civil procedure rules. So well, you show me where it is, I can't see it. Oh, well, it must be. Or they say, well, it's what we did on the last job. And I think it's a real problem. And you look at what the RICS say, so as a chartered QS, you look to the RICS guidance for surveyors acting as expert witnesses. And I'll quote this, they say it's generally best if such meetings occur before reports intended for disclosure are exchanged, as expert witnesses can be slow to alter opinions after signing a report. And it's often said that this approach saves cost. Well, I think you've got to consider what is the nature of the evidence that you're looking at that's forming part of the joint statement. I can see situations where, taking Russell's discipline, looking at delay analysis, it would certainly make sense to me that you might have a joint statement early to decide what's the baseline program that you're going to measure the delay against. What method of delay analysis is going to be used? Otherwise you get the two delay experts obviously choosing different approaches. But having said that, if you look at quantum, I don't think it does work, and I don't think it saves cost to actually do it before reports are exchanged. Now, I've been involved in many cases where you get involved after the timetable has been determined. Nobody actually asks the experts, and why should they? But you get involved and you're told, right, you're instructed and you've now got to produce a joint statement with the opposing expert on a number of variations, and you've got to do it within 3 weeks or a month or 2 months, whatever it is. What you find, or what I've found, is you've got to do as much work to actually form the opinion as you might do in actually drafting a report. So what happens? People are you're a little tentative. You don't necessarily form a considered view. So you produce this joint statement. The other expert, no doubt in the same position, you end up with a table of variations. You then do a first round of reports, so you can comment, but you don't really know what the other party's position is, because you've got the joint statement, it's not often in a lot of detail, and I'm going to talk about what should be in the content a little further on. So I think it's important to give it more consideration as to when that joint statement should be made. And I think there's a tactical issue as well here that I think is often overlooked, that I've been involved in cases where if the joint statement is done after the reports, you might get a situation where a particular expert has taken a very bullish approach on, let's say, lack of records, and he supports everything in his report. You then have the joint statement meeting and he reads your report and he says, oh yeah, I can see, that's all rubbish, I'm going to drop all that. So he concedes it all. But what he can't do, he can't actually withdraw that report. And I've seen experts get horribly taken down in cross-examination where they say, they're asked that question, why did you say I could support all of that? And the answer is, well, I've conceded it. I've now agreed it in the joint statement. And the question remains, but why did you say it in the first place? And it goes to, obviously, credibility. So I think that's a tactical issue. In terms of content, and again, whilst not directly applicable to arbitration, civil procedural rules give us a good guide. Part 35 talks about joint statements, identifying areas of agreement, areas of disagreement, and what are the reasons for disagreement. And I emphasise that because my experience generally is that lots of expert joint statements comprise nothing more than both experts' opinions. And they set them out in a table, Mr. X and Mr. Y. What you never see, or very rarely see, is that phrase, the reason we disagree is because. And it's obviously less confrontational just to put down two views. Now, when I was preparing this talk, Nicholas pointed out to me the ICC Commission report on construction industry arbitrations. Now, interestingly, paragraph 18.4 of that document states, too many joint expert reports are burdened with what is already known and accepted and don't concentrate on the reason for different opinions. And I just give one example of this. I was involved in a case where, and I'm going to contradict myself a little bit and say this was a case where the joint statement was useful to be done before reports. It was where we had to produce cost plans. So my suggestion to my opponent, who was also a chartered QS, was, why don't we agree that we'll prepare our cost plans based on the RICS NRM structure? Now, I thought that was fairly uncontroversial and ought to be fine. So I sent him a draft with that in there. It came back deleted. No, I don't want to agree to that. So I said, okay, absolutely fine. What we'll do then, we'll say the reason we disagree on the method is because you, Mr. X, and I left it ... You fill it in for me. And the next draft came back with that section then agreed. So I think it's a powerful tool for experts to actually put the person on the other side on the spot, say to them, what is the reason? How do we explain why we disagree? And that, and I probably, it takes me nicely into my third point on lawyer involvement, because I feel that potentially there was maybe a little bit of pressure on, I don't know why you wouldn't agree to do a cost plan according to NRM, but I think maybe this individual was told, we don't want to agree much. And I think Dan made the point that lawyers often say, don't get involved in agreeing this, that, try and do whatever you can. Now, I appreciate we're talking about arbitration, but if you look in the litigation sphere, obviously the TCC and the authorities take a very different view on this. There's the BDW case in 2018, a very recent case of Pickett and Balkind, I think a couple of weeks ago, seriously admonishing lawyers for interfering in the joint expert process where they actually want to be involved in the drafting, not just actually looking at defining what issues the expert should tackle, but actually saying, well, I want to see all the drafts and get involved. Now, my experience of arbitration is certainly that is the case, that lawyers do want to get involved, and it will be a topic for debate here as to whether that's right, wrong, or indifferent, but many of the cases I've been involved in, the whole process gets drawn out because every draft that is done, the expert sends it to the lawyer takes a day to look at it, they then return it, it's sent to the opponent, his lawyers take a day. Nobody actually admits that that's the reason it's taking so long. But there is an issue here that people, I think, are probably paying lip service to what the proper approach should be. So really, I suppose my final comment on that is, in terms of lawyer involvement, should it be all out in the open, or should the CPR rules and the recent cases in the UK be followed?
Gary, thank you very much. Kim, any experiences on joint statements and before or after, and or lawyer input?
Absolutely. So actually, Gary's made a very powerful case for treating quantum experts differently from delay. And from a tribunal's point of view, it's very important that the delay experts agree their methodology before they start work, because otherwise you have two competing methodologies, and how on earth is the tribunal going to decide between them other than by deciding between the experts? So they have to do some putting of the boot on one of the experts in order to say which methodology they prefer, which is not desirable and ought not to be necessary. So the sooner the delay experts can meet, the better. But I can see it's different for quantum because you need the numbers to crunch, and you're just going to be talking about things in the abstract otherwise. So I am going to make a mental note of that. Thank you very much. The joint statement is hugely useful for the tribunal. Now, it may be said that it's the only document the tribunal looks at. Well, if it is, I couldn't possibly comment, but who could blame the tribunal? Because we're back to the very beginning. What is it they've been asked to decide? They don't have to decide things that are agreed. They are only there to decide the things that are still in issue. So the joint statement, the more the experts can agree, of course, the happier the tribunal is. The more focus the experts can bring to the issues, the shorter the process will be, and the more useful the answer will be from the tribunal.
And it seems to me that there's if you are going to direct that the joint statements be after expert reports, that absolutely shouldn't be a reason to stop the meeting before. So the idea that they should meet at least to sort of snarl at each other and have a look and sort of discuss the themes that they're going to be covering in their reports, even if they don't end up signing an agreement, is still an appropriate course. You're nodding vigorously there.
So again, this may come as a shock to the parties, but the tribunal isn't interested in the tribalism that will have built up for the duration of the case. There's nothing more toe-curling from the tribunal's point of view to see the experts slagging each other off. It's not professional, it's not consistent with their obligation to help the tribunal, and again, it's just a complete waste of time. I was presented with a 70-page joint statement. When I went down the agreed column, I found one item of agreement. And I pointed this out to the experts, and they sort of said, oh, yeah, well, there's not much, is there? And I think, how is this helpful? What have you been spending your time doing? And if you can't, so this was an earlier point, if you can't agree the other party's approach, can you not at least value it? Because you never know, I might agree it, and then if I haven't got the alternative valuations, then we're either going to have to come back and go through the grisly process again, or I'm going to lose patience with you all and find against the greatest rule breaker. So if I could urge the experts to remember, they have to rise above the foray and be as helpful as possible and as professional as possible in their dealings with each other for the benefit of the tribunal.
Yeah, Nick, any thoughts?
I agree with what you said, Kim, completely. And just on that, I think any form of witness tampering, even a professional witness, is completely unacceptable. International arbitration is self-regulating, and it's global, and so there's a lot of it going on in international arbitration, but it's completely unacceptable. On the point of early meetings prior to exchange of reports, I also agree, Alexander. There are surely things that can be agreed at a first meeting, even if it's recognition of the other person's details and CV and what are going to be the uncontroversial sources of information that both parties will be interested in. All of those things can surely be agreed. If an expert witness doesn't have the confidence of his or her independence, then that may be a problem. But I think a first meeting for as much of the preliminaries is well worth it. And that then gets the two individuals in the single discipline into some sort of appropriate dialogue in the interests of correct decision.
Any experience, Dan?
So coming back to my earlier topic of document requests, I will start by saying I agree with Gary that actually trying to pin yourself to your final opinion before you've done your report is not helpful. It's not until you've actually done the analysis can you come to the conclusion as to what your opinion is. But there's definitely benefit and merit to early expert meetings on targeted questions. And the more interesting the matter is, the more that becomes a benefit. So where there is questions over approach to methodology, approach to documents you require, and actually having those early conversations, not saying what your conclusion is, but at least agreeing sometimes your approach or what you need to get to a conclusion can be beneficial. But it is entirely dependent upon the willingness of the other side's expert to engage in constructive conversation rather than not.
Thank you. Right, I see we're nearly out of time. We've obviously covered pleadings against memorials, sampling and document production, witness statements, expert instructions, and timing and content of joint statements. So we've covered, I think, everything except the award, which we obviously won't be doing today.
I'm Richard Wilmot-Smith. I'm going to introduce the panel and what we intend to do, and the order in which we intend to do it. And we are going to stop at 5 o'clock sharp. I'm also going to occasionally just stop people when the time is up in order to keep everything absolutely on track. First of all, we're going to do, in relation to this panel, we're going to talk first, and Philip's going to start us off, first about arbitration. Then we're going to segue into both arbitration and adjudication. And Hamish is going to do that. Hamish is now Paul. I've not transmuted, I'm not Doctor Who, but, and then Sean and Karen and Philip, but we're going to start with Philip, then Hamish, and then we're going to segue into adjudication. Now, to introduce the panelists, I'm going to start first with Karen. Karen Goff is in chambers with me at 39 Essex Chambers and practices internationally as counsel. She's also an attorney at law, an arbitrator, adjudicator, and she has been specializing in construction disputes for over 30 years. And I say that to my certain knowledge because I was at 22 Earl Buildings, Lincoln's Inn, which is now Atkin Chambers, when Karen arrived there as a Robert Aikenhead's pupil, I think. She's appeared in many cases in the courts of England. The CV says England and Wales, but I think it's primarily England. And in the Caribbean, she's a chartered arbitrator and an ADR practitioner. Her CV includes the fact that she is currently vice chair of the SCL, but she is also a past president of the Chartered Institute of Arbitrators. Now, Faye is primarily a quantity surveyor, chartered quantity surveyor, and she has over 25 years' experience in the construction industry. Now, she started training as a QS at 18 and worked predominantly with the main contractors. And she completed her Bachelor of Science honours degree in quantity surveying part-time at the University of Westminster and later undertook a postgraduate diploma in law at Middlesex. And she's a fellow of the RICS, accredited expert witness, and a practicing member of the Academy of Experts. Faye rather reminds me in one respect of my own mother, who was a veterinary surgeon, who wait for the reveal. wait for the reveal. When she arrived at the farm, and when Kay arrived on site, Faye arrives on site, the farmer would look at my mother, this is in the 1930s, I hasten to say, and 1940s, and say, where's the vet? And we're going to come to a theme from which that story comes. Now, Hamish Clark, a.k.a. Paul Mansell, is a chartered arbitrator of more than 35 years' experience and is a practicing architect. And he's acted as an expert architect on 29 occasions and has been a member of a team of experts on many, many occasions. He's given evidence and been cross-examined in the ICC in Singapore, the LCIA, Court of Session in Edinburgh, and provided concurrent evidence, hot tubbing, which I'm a great fan of, by the way, in international arbitrations and remote evidence, and in virtual hearing. His appointments has included disputes with values in excess of $250 million, and he's provided expert advisory services in the defect and dispute investigations. Now, Sean is well known to you because he has been the convener of this. He is himself founder of UK Adjudications. He's CEO of Global Expert Witnesses, the firm Hanscom International, and sits as a quantum expert witness and undertakes works as a tribunal, arbitration, adjudication, mediation, and dispute board member. He's listed on the FIDIC President's list as mediator and adjudicator, and is currently serving in both capacities in Asia and the Middle East. And he's worked across the continents of the world in his career, throughout the world in his career. Now, the last one is I'm going to introduce is Philip, and his is going to be the shortest, and the reason is because he's going to be the first I'm going to call upon. He is an adjudicator, arbitrator, and mediator, and has had 40 years' experience in the construction industry, he is suffused with knowledge of what we're about to talk about. And just to remind you about what we're doing, we're starting off with arbitration. We're going to segue through Hamish, arbitration, mediation, and then we're going to talk about adjudication. Philip, thank you so much.
Yes, I think the black and white photograph really denotes extreme old age, but never mind, I'll try to get through this. So I was given the topic of improvements in adjudication and arbitration, and I said, well, look, as regards adjudication, and as people have been saying all day, really adjudication seems to be working pretty well. So, you know, if it ain't bust, then don't try to fix it. And so, as Richard said, let's move on to talk about arbitration. And really, you know, many times today, people have said arbitration is almost a threat. You know, if all other forms of dispute resolution fail, then we'll threaten you with this retrospective, slow, formal procedure that's going to cost a fortune and that we all don't really want. And as Maggie Thatcher said, no, no, no. I mean, arbitration is inherently flexible and it has a huge potential dynamism. And you know, even to this day, you have arbitrations, the look-sniff arbitrations, where an arbitrator picks up a fish or crumbles some corn in his hand and says it's good, and that's the end of the arbitration, and it's final and binding. So we have an immediacy for arbitration, which we seem to have lost sight of. And so my first idea, which I'm throwing out, is adding salt to arbitration and to construction arbitration, is the fast-track, proactive arbitrator. And although I do deal with large and very large construction disputes. What I'm really talking about today is, if you like, the run-of-the-mill, normal building and civil engineering disputes. So one idea is to have arbitrators of different disciplines who will commit to attend to disputes within the duration of the works. We've heard about catching problems in the currency of the works and within a very short time frame. And they would resolve disputes on an inquisitorial and investigative basis, so taking the initiative, as they can do under our statutory scheme, the English statutory scheme, in ascertaining the facts and the law. And they would be listed in the contract. There'd be short lists of arbitrators of different disciplines, for example, structural engineers, architects, mechanical engineers, quantity surveyors, etc. And the idea is that Muhammad goes to the mountain, that the arbitrator goes to the mountain of the dispute. The function of these arbitrators would be attendance on the parties whenever they wanted it, hearings virtual and actual, or on site. They would get themselves to site if required, and they would sign up to this. The fast-track frameworks would be well within the adjudication timeframes for practical issues such as building failures, fabric and structure failures. The timescale could be much quicker than arbitration, maybe within a week. And then in dealing with the practical aspects of the build, the arbitrator will be empowered to issue instructions within his award in substitution for instructions already given, and so a corrective opening up, review and revising role during the currency of the project. And then these arbitrators, these named arbitrators, would enter into short-form contracts with the party to the building contract or civil engineering contract or whatever it was, committing to this regime. And then you would have a let-out clause, of course, which says, look, if I really can't do this, and then you would move to somebody else who would be appointed by a nominating body from a panel of people who are prepared to do this relatively urgent work. So the policy would be to have proactive arbitrators on, as I say, normal construction projects in the UK, working as far as possible to resolve disputes during the contract or very quickly at the end if need be. Somebody was saying right at the beginning, what's the problem with arbitration? The answer is the arbitrators, because we haven't got this frame of mind of dealing with things quickly, of being prepared to sweat and deal with matters urgently. So it's a change of dynamic where the arbitrator goes to the mountain of the dispute and not vice versa. It stops arbitration being retrospective, and it allows a dynamic correction of the contract process as well. Now, people will say, well, we've been hearing all of this. We've heard about dispute boards. This is like a dispute board, or this is like a 100-day arbitration, or this is like an emergency arbitration. So the natural lawyer's instinct is to find a hole and pigeonhole things. But this isn't that. It's not emergency, because the whole message is that for any dispute, however normal or routine you may think it to be, it's urgent to the parties. And that's where the proactive thing comes in. It's not a dispute board, it's a sole arbitrator. And it's not a 100-day arbitration, it could be a 3-day arbitration. So, let's not pigeonhole this and dismiss it. This is something, an approach which can be enshrined consensually in contracts to make them work, to make them fair. So we move away from this idea of retrospective, formal, stayed arbitration proceedings that really people want to avoid. And because we're in the real world, will arbitrators make money out of this? The answer is yes. I mean, this is akin to injunctive proceedings in many ways, and lawyers expect to be paid for injunctive proceedings, so they would be expected to be paid well for this kind of work. You could put teams together of very, very well-remunerated people, and there'd be As long as you do it quickly and as long as you deliver the result, that will be fine. The next idea then, which I was talking to Paul, who is now Hamish, about is we take the word dispute, we take dispute resolution, we take dispute out, and we talk about problem resolution. And Paul and I were actually talking about this in the context of BIM. But this wouldn't necessarily fit into statutory adjudication, statutory arbitration. It may have to be done on a consensual basis. But we move forward and we say, you do not have to have a dispute to come up with a resolution. It's a radical new approach. As I say, it's consensual. The problem resolver will be empowered to decide and declare a practical solution to a problem referred to him without apportioning blame. The parties bear their own costs, they pay the problem resolver equally, and it would be binding, and I would commend to you binding and final with no appeal. It would apply to situations where the parties didn't want to know who's liable. They didn't care who was right and wrong. They needed to solve a problem. So it would apply to methodology, it would apply to buildability, it would apply to engineering performance, it would apply to process engineering and production lines and all kinds of manufacturing, and it could apply to really all technology where somebody just wants a problem solved. They don't care whose fault it is, they just want a problem solved. And it would apply in particular to situations where you want collaboration and cooperation, and that is essential. And that's where I was talking to Paul about BIM and where people are working together in a sort of virtual environment with shared responsibility, and they've got to find a solution to this design issue. And that's where I think, problem resolution rather than dispute resolution really kicks in and really earns its crest. So without more, I pass on to Hamish, who is Paul, or Paul, who is Hamish. Thank you.
Thank you. Hamish will talk for about 5 minutes before we go on to the next. Thank you very much, Philip. That's very... Can you hear me at the back? That's very illuminating. Much appreciated.
Thank you, Philip. I'll do my best to stand in for Paul. He's been taken rather poorly in the last 48 hours, but he did give me permission to say this. He's actually having a CT scan today, so we're going to get our very own BIM model of Paul emerging soon that we can all interrogate and get as much information out of it as possible. Perhaps I feel a wee bit of suffering from imposter syndrome. You probably think I should be a young techie that's standing in front of you discussing BIM, but maybe the fact that I'm standing here, it helps illustrate some of the issues. In that, first time I worked in an architect's office was in the 70s, and the first thing I had to do was to watercolour 8 sets of drawings to be issued to a contractor. So there were like 50 drawings, all watercoloured, all the different colours. And that determined the volume of data that was involved in the job, And since then, the whole industry's progressed. So, since the early 2000s, there's been a rapid acceleration of the digital environment in which we're all working. But I don't know if the dispute industry or the solution industry has accelerated in the same way. And many of the procedures that we follow actually hark back to the watercoloured set of drawings that I was doing in the 70s. And maybe we should be thinking about the actual information that's being generated by the industry and how the dispute industry should be, and how we go through arbitrations and adjudications, how the information that is available can help resolve the problem. So there's three things I'd just like us to consider. Building information modelling, BIM models, as we refer to them. It's now commonplace in the industry, for a design to be a single collaborative digital environment with multiple parties contributing and sharing information in a single virtual environment. Now, I think we're all used to the concept of a 3D model of a building or a facility, or it could be a piece of equipment, a piece of engineering. But actually, the BIM model has far more in it than that. It's got a record of everything that happens, so it tracks all the changes that people make to that single model. You know, it can assess the causation of an issue that's arising. You know, it can analyze an impact very quickly if you start interrogating that model. So, you know, by interrogating a BIM model, we can see when a design change was made, who made it, and what the impact of that change was. So it's not just a graphic representation. It's got far more to do that. So, you know, analysis can check how well different components, such as steelwork and building services, have been introduced into a design. When this occurred, if the clashes between the components are evident, and how these clashes may impact upon progress of the work. So when objects in a model, you know, for instance, a steel beam, are attributed with costs, programming data, we find ourselves with an incredibly powerful tool. So BIM models are far more than just a 3D image of the building. They've actually got masses of embedded information that can be used in a dispute. Something that we're all probably fairly familiar with are common data environments, or CDEs. You know, so that's parties collaborating on a project where they're sharing information in, if you like, a digital filing cabinet that's there recording all the activities on the job. You know, so you know, in a similar way to models, CDEs often hold that vital contemporaneous, evidence needed to, make or break a dispute. They can easily dispel spurious claims that a party was unaware of a particular document, and download records, may demonstrate when a team member received information, So, these data repositories are often, if a dispute arises, held as a ransom as well, So, in many cases, if one of the parties, loses access to the CDE, which typically has been held by one of the other parties, there can be a lengthy disclosure process. And I think the disclosure process related to BIM models is really important, because it's maybe not evident what information is contained in a BIM model. When a model is released to the other side, or one party holds it, what is actually in that model? What has been redacted from that model? What has been removed? So we're all familiar with the metadata, say, in a photographic image, but BIM models have got the same level of data buried in them that can reveal all sorts of activities within a project. So, they're not simply representations of a design, and they're not simply electronic filing cabinets. They contain they're the CT scan of the project in many ways, and some of my colleagues refer it to, the breadcrumbs that enable the parties, the lawyers, the experts, to understand what is going on, So that's it on the evidentiary side of it. But also, in terms of a tool, when it comes to expert evidence, technical expert as I am, we should be looking at other ways to present that evidence. Are we still bound by printing out documents? It's now all digital, but it's very easy to see how you can have a 3D model that's got a program embedded on it, showing how the production of a piece of plant, or a building, or a facility, how that was generated over time, and the impact that, say, a design issue that wasn't properly coordinated, when that occurred in that programme, and the flow of actions that came from that. So hopefully, if we can think about these issues, we can get closer to finding out actually what happens on jobs and projects when they go wrong by interrogating these models, get to the solution of the problems rather than looking at them as disputes. And the type of evidence that can be produced using the likes of a BIM model enables the decision makers to make the best possible decision. So, thanks very much.
Thank you, Hamish, very much. I'm changing the format slightly, so they're going to be a little bit surprised. Faye is going to go next with her presentation, and then we're going to move to a discussion of the themes which come from Faye's talk. And you will see shortly the relevance of my reference to the young vet turning up on the farm and the young quantity surveyor turning up on the site.
So basically the topic that Sean and I were given was what improvements could there be in adjudication? And I know, Philip, you said it's not broken, you don't need to fix it, but we disagree. So we threw this question out to quite a few people, and we came up with a number of things that seem to be a repeating theme that people do think needs changing. So the first one is jurisdictional challenges. I'm sure the adjudicators in here are all very well aware that that happens on pretty much every adjudication. It can waste probably a good few pages at the beginning explaining why you haven't resigned, and you will get numerous challenges that are a complete waste of time. We came up with time frame. It's often too tight when you get large disputes that are quite detailed. You might have a final account thrown at you. You get parties who argue and don't want to give more time. So should we give the adjudicator the right to automatically give time without needing permission? We had consideration when setting those time periods when you're asking for this time, when you've got difficult people and they're all arguing over rejoinders and surrejoinders, how much time do we need to give? So that's probably one of the main ones we wanted to talk about. Party costs, is there a chance that the adjudicator should be allowed to deal with that in more detail? Clearer definition of the issues. Some of these adjudications, they come in from non-legally minded people. They don't explain their case particularly well. Do we need to work on clearer definition of the issues? This is a favourite one with the experts, name calling. There's quite a lot of name calling of experts. When you spoke about witness evidence earlier, I thought that was quite interesting as well, because obviously we get quite a lot of the submissions in adjudication where a witness will come and try and basically say that the expert report isn't correct. Again, speaking to the factual terms, they shouldn't really be commenting on that. The pool of adjudicators is a big one that we've discussed. The panel, getting onto the panel is quite difficult. Sean and I, and Gary knows as well, we've had a bit of a discussion about this recently. We've got, I just have to ask the question, who in here is an adjudicator and can you stand up? So I can see 3 women, no, 4. Okay, so out of this realm of people, that's quite poor. So diversity, have a seat again, or the lack of is quite a serious issue, and it's not going to change unless we all work to change it. And decisions, should we ask for more reasons from adjudicators? So basically they're the topics that we've come up with, and we thought what we'd do now is basically have a little bit of a discussion as a panel, and you can throw some questions at us as well.
The last point relates to the farmyard, and that relates to diversity. In the 1930s, my mother was the first female vet to basically go on farms. The generation of Karen and Faye, they are the pioneers of adjudication, females in adjudication. It's not just gender, it's colour, it's age, it's all sorts of things. Could perhaps first Faye and then Karen, could you kick something off before we ask Sean to say something about it?
About diversity?
Yeah, in adjudication.
Right.
Or lack thereof.
Or lack thereof. I mean, I'm looking at Kim's sitting down here. I don't actually think that there is a bar to women in adjudication. I think there are lots of bars, not just specific to women, to people getting onto adjudication panels and becoming known. And I don't have a recipe as to how that can be achieved easily. You know, you just need to get started somewhere, somehow. There are some panels that you can try and get onto, but basically you need to put yourself out there as somebody that is qualified and able to do adjudication, and cross your fingers that somebody's going to ask for you. Or if you're on a panel and it goes round in a rota, I think Tesca and Tech Bar, they have a rota they just go through, and your name comes up. So, yeah, there aren't many women adjudicators. I don't think that necessarily that's a problem of the panels and the people that appoint them.
I think you can probably go there, Sean, next, because we've obviously had the discussion.
I disagree. I think a lot of the institutions, professional institutions in the country, when they were originally founded, were founded in Victorian times, and they were racist and sexist and classist and elite. Those institutions aren't like that now. But what you do have is a small pool of people that tend to be adjudicators on a lot of the panels, and that's prevented diversity. Some of them state when they're going to open up the panels so people can apply. So they might say, for example, every 2 years our panel will open. UK Adjudicators has been founded 5 years and we're open for people to apply to join the panel. In terms of diversity, we're not happy with the diversity that we've got, but we've tried to be extremely diverse in terms of people's professional backgrounds. We encourage people to apply of any race, gender. At one point, we had an extremely high ratio of female adjudicators initially. Because the pool's grown so rapidly, we've got an extremely low figure. In terms of my understanding of the marketplace in the United Kingdom, I think Tech Bar have the largest amount of female adjudicators. I think there's 12 or 13, my last count. I think 2 or 3 of those are on our panel. When you look at some of the other panels, I don't think there's any women on there at all. So, for example, I believe that the ICME hasn't got a single female on there. I might be wrong, but they don't publish their panels. If you look at Tech Bar, they tell you who's on the panel. UK Adjudicators do that. We publish our panel members' photos. And I think unless the panels, the bodies running these panels publicly allow people to see who's on their panels, things aren't going to change. And I think that's extremely important, is the public, the users, want to know who's on the panel.
I think another thing that we spoke about that goes into that is obviously people can ask for specific characteristics and experience, and the problem you've got with the issues we have, where we were talking about a certain colleague that we've got, is when you're young and you don't have that experience. It's that old adage, isn't it? You can't get the job without the experience, you can't get the experience without the job, and that is what the problem is with trying to get on some of these panels is. So, you know, Sean's been kind enough to sort of say that he will help with this, but it's whether the other panels will as well. And I know that there's been discussions with the RICS recently, and there is a view that if you are too young and considered to be too inexperienced, it's going to be very difficult to get on the panel.
I'm going to mention somebody who sat here, Matt Malloy. Matt Malloy does an extremely lot of work mentoring people and pupilages, and he's helped so many people be able to get onto our panel. And I think that's one way we can increase diversity and opportunity for people. And it's only the work of people like Matt, where he's giving up his time to do this, it's actually making a real change. And I'd encourage anybody who's an adjudicator here to try to mentor, offering pupilages or some other similar training and shadowing opportunities, and then we're going to be able to change the status quo. But unless people are putting themselves out to do this, things aren't going to change as quickly as they need to.